For motion, item number 1.
My Lords, this public interest litigation is with respect to an acquisition of 155 acres of land, my Lords, in the Lengpui area. And my Lord, our contention in this case is basically this, my Lord, that the Land Acquisition Acts, the laws of land acquisition, my Lord, has been diluted for the purpose of this acquisition, my Lord, which consists of 199 crores of amounts of rupees, my Lord, the acquisition amount. Now, the reason why, my Lord, we are saying that it has been diluted, my Lord, is because of two reasons. My Lord, the first reason is because the owners of the lands, as reflected in the LAC and the draft award, my Lord, they have not been given, they are not the ones who have been given the compensation amount. That is the first, my Lord. And the second, my Lords, is the land acquisition laws. The laws of land acquisition has certain procedures which has to be followed. And this entire procedure has been diluted. And now when the issue contains, my Lord, when the issue is with respect to 199 crores, the question, my Lord, before this court is whether the Land Acquisition Act can be diluted. Because the safeguards provided in that procedure, my Lord, in the Land Acquisition Act, is important, my Lord, because in order to prevent arbitrariness, in order to prevent even corruption, my Lord. So because of this reason, my Lord, we have come to this court. Now, my Lord, coming to this first reason, if your Lordships will see, at page number 73,
Yes.
now, my Lords, this LSC is in the name of H.L. Samuela. And the second LSC, my Lord, is at page number 81. Now, this is supposed to be in the name of Thanzwala. And then the third LSC, my Lords, at page number 88. This is in the name of Ram Fangzawa. And the fifth LSC, my Lords, at page number 99.
Fourth, you mean?
The fourth LSC, sorry, in the name of Lal Khamwani.
99.
Page number 99, my Lords.
Yes.
And then the fifth LSC, my Lord, in the name of Larin Pari at page number 106. And then the sixth LSC, my Lords, at page 117. In the name of Biak Loma. And finally, my Lords, the last LSC at page number 124 in the name of KLL Dua, my Lords. Now these LSCs, my Lords, all of them were supposed to have been converted from periodic pata, which was in turn, my Lord, initially village council passes, my Lords. I would like your Lordships to note this. Initially they were village council passes, then they got converted into periodic patas, and then eventually they got converted into LSCs.
So what's wrong?
Now I'll explain to your Lordships. Now, my Lords, after these LSCs, after these land documents became LSCs, they were allegedly sold, my Lord, at page number 132. As I had explained, my Lords, we are raising two issues. The first is with respect to the land documents and the acquisition, and the second is with respect to the procedure of the Land Acquisition Act, my Lord, how it has been followed. Now, I'm dealing, my Lord, at this stage with the ownership of the lands, my Lord. And this is with respect to this is a cell deed between KLL Dua and the respondent number 14, Sri Rohming Liana, my Lord. This is at page 132. Now, my Lord, as per this sale deed, the land was allegedly sold to Rohming Liana on 9th May 2005, respondent number 14. And then, Lordship, on the next page, at page 133, a similar sale deed was made. This was also made on the same day between Lal Khamwani and Sri Rohming Liana.
Yes.
And similarly, my Lords, at page 134, this was made between H.L. Samuela and Sri Rohingyana. And then at page 135, this was between Sri Biakloma and Sri Rohingyana. Then at page 136, between Sri Thangzwala and the same person. Then 137, between Sri Ramphangzawa and Rohingyana. So, my lord, these cell deeds were made, all of them were made on the same day, that was on 9th May 2005. Now, subsequent to this, my lord, what happened was in 2019, on the next page, my lord.
There are only 6 cell deeds.
Six, there are only 6. And one of the owners, my lord, is supposed to be the wife of the respondent number 14. So, I think there is no separate cell deed
Who
for
is
that.
the wife? Who is the wife?
My lord, the wife is Lalthamwani. Sorry, not Lalthamwani. Lalrin Pari is the wife, my lord. At page number 106, the LSC is at page 106.
Lalrin Pare is the
Wife of the respondent number 14.
Yes.
Now, your lordships will come to page 138. Now, this was in 2019. This was after the cell deeds were made, my lords. And here it says to whom it may concern. And it's written like this, my lords. It is to inform that the under-mentioned landowners within the 211 acres surveyed land assigned Mr. Rohingyana, son of C.L. Thuama, late residents of Vivakon Zone, Huai Aizol, Mizoram, as the representative authorized and our behalf to deal with all matters related with negotiations and land compensations, including the final payment of award, which may be deposited in his account, whosoever is assigned power of attorney. We have no objection. This is to ensure early land acquisition for any central project. Now, the name of those individuals, my lords, are reflected. So this was, even though the cell deed was made, my lord, it has been reflected here as he has been shown to be authorized person only, my lord. Now, V.L. Samuela is, my lord, the first person. Then, lordship at serial number 4, Mr. Thanzwala. Serial number 5, Mr. Ramphangzawa. Serial number 6, Mrs. Lalthamwani. Serial number 8, Mr. C. Thanlira. Serial number 9, Mr. Biakloma. And serial number 10, KLL Dua. Now, your lordship will see there are 7 persons here.
Yes,
the reason why there are 7...
Where is the wife of respondent number 4?
Exactly, my lord. Initially, the land in the name of the wife, my lord. Initially, the name in the name of the wife was owned by serial number 8, Mr. C. Thanlira, my lord. So, her name is not there, but Mr. Thanlira's name is there, my lord. So, this authorized... So, even though the LSC has been made in her name, my lord, he has continued to be the signatory. He appears to be the signatory with respect to that particular
And
LSC.
who are these other names? Who are these other persons?
These other persons, my lords, I have shown the LSC names. Or the other persons, my lord, these ones, my lord, I don't know, my lord. These ones, they're not part of this. They're not in the factual thing, scenario. So we are not...
So, the thing is, now the property that was sold, the land that was sold,
Yes.
it is covered by the 7 LSCs, or is it beyond that?
My lord, as far as my knowledge is concerned, it is in these 7 LSCs, my lord, within these 7 LSCs.
How do you know? Have you added up the area?
No, my lord, because of the award. My lord, the award has consist of the names of these 7 LSCs. Yes. And if your lordships will see the next document, which is at page 140.
Yes.
Now, this was on 25th September 2019. This was before, my lord, the land acquisition proceeding was held. There was a meeting of the land acquisition held in the office of the additional deputy commissioner, my lord. My lord, I'll read this. It says like this. PVL Huaizela Kyangte, additional deputy commissioner, Aizol district, chaired the meeting. At the outset, the chairman welcomed the landowners for sparing their valuable times to attend the meeting and highlighted the points to discuss in the meeting. A lengthy discussion was held. The landowners at Sipir technical area highlighted the location because there are 2 areas which were acquired. One was at Sipir and one was in Lengpui. We are only concerned with Lengpui.
Now we are concerned with
Lengpui only. Highlighted the location importance and is located near the main road to Aizol to Silchar Road, and the land where situated is surrounded by high hillocks where tourism could be promoted. Then the landowners demanded land value more than 250 per square feet. Likewise, a lengthy discussion was also held in regard to land at Lengpui administrative area. The landowners highlighted the importance of land. It is located near Lengpui Airport, which is the only airport in Mizoram. The lands adjacent to this land was also acquired for airport at the rate of rupees 60 per square feet in and around the year 1996. Hence, they demanded land value more than 300 per square feet. After a lengthy discussion, the landowners were requested to make decision, and they agreed as follows. The land value at technical area at Sipir will not exceed 185 square feet. The land value at administrative area at Lengpui also will not exceed 185 per square feet. Now, Your Lordship will see the next page. This was attended.
You go straight to the award. Why are you taking us through all this? Let us see what is the case all about. What is the case about?
So,
make it short.
So the case is about this, my lord. First of all, even though there are allegedly seven landowners, my lord,
7 lakh owners?
seven landowners, seven
land
LSC owners. LSCs are owned
Let us see the award.
Yes.
Where is the award?
Yes. My lord, the award is at page number 116. This is the award, and Lordship will see the next at page 168. These are the name of the landowners.
160 is the award.
It starts from 166, and then it goes on to 168, my lord. In fact, 169 also is there.
Award for land acquisition. So this award is there. So what is wrong with this award?
Now, yes, my lord. So now what happened, my lord? If your lordship will see at page 170.
Yes.
Now, my lord, this was an undertaking made between made by Rohming Liana, my lord. It says like this, at serial number 1, that I am the rightful owner of the landed properties which are covered by the LSC number so and so. So the LSC numbers are given, are situated at Lengpui Serzol Road, Mizoram. These landed properties have been acquired, purchased by the Indian Air Force for establishment of Indian Air Force establishment area within Mizoram, and the compensation pecuniary benefits arising out of the acquisition sale of my landed properties is to be disbursed to me soon. That whereas the original copies of the above mentioned LSCs need to be submitted to the district collector, Aizawl district, at this stage for disbursement of the compensation pecuniary benefits arising out of the acquisition sale of my landed properties, I could not produce the same, as I had mortgaged all these LSCs in the IDBI Bank Regional Office, Gauhati, to avail of the loans which are not yet liquidated till date. That by virtue of this undertaking, I swear, affirm and undertake that if rupees 30 crores of the compensation pecuniary benefits arising of the acquisition sale of my landed properties could be partly disbursed to me at this juncture by the district collector, Aizol district, or any of the concerned authorities in this regard, the pecuniary amount to be given to me shall be utilized by me for liquidation, clearing of my loan dues, and then I will redeem all the original copies of the above mentioned LSCs from the IDBI Bank Regional Office, Gauhati. Thereafter, I will submit such original LSCs to the district collector, Aizol district, or to any of the concerned authorities accordingly as necessary, and I further agree to receive another rupees 40 crores of the remaining undisbursed amount of compensation, so on and so forth. So, my lord, now what happened? Now, as per the draft award, my lord, your lordship has seen, the lordships has seen that he is not the landowner, but here he claims to be the landowner. And if your lordships will see at page number 174, what is interesting, my lord, is this is an RTI reply. At page number 175 is the content of the RTI reply. Now, here it says, my lord, the type copy is at page number 175A, my lords, translated copy. It says like this: LSCs belonging to 7 people were acquired for the establishment of MPR.
Which page?
My lord, at page 175A is the type copy, my lords.
Yes.
This is the RTI reply, an RTI reply.
Yes.
LSCs belonging to 7 people were acquired for the establishment of MPR for IAF at Lengpui, and the detail are as follows. And the names of the individuals whose lands are acquired are given, my lord. And finally, it's given details of payment. Now, the details of payment shows different people, my lord. The first is Henry Remsang Lon Mual, son of H. Thandlira, and an amount of this much amount was given to him. And then Roming Liana, and number 3, Roming Liana. So the amount was given to 2 different other persons, my lord, not to the landowners, my lord. So what we are concerned here, my lord, first is that the ownership of the land in this case, because the owners are different, and the payment was made to 2 different individual persons. My lord, this creates, we are saying, my lord, the land acquisition laws to a certain extent has been diluted, even on a prima facie understanding of these facts, my lord. This is one. And if your lordship will come to page 177, this is a Mizo version, but at page 177A, we have a translated version, my lord. This was signed by one of the landowners named KLL Dua. And it says like this, my lord. On this day, the 21st of January 2016, I, KLL Dua, son of so-and-so, resident of Lengpui Vengthar, do hereby declare that in respect of the land situated at Par Ching Cheng, Lengpui, presently recorded in my name under LSC number so-and-so, I had no involvement whatsoever in the process of conversion or alteration of the said land from a village council periodic patta to a land settlement certificate. Further, with regard to any application made for such conversion or any transaction relating to the purchase of the sale of said land by Puro Minglian, a resident of Vivacon, including any sale deed executed on stamp paper, I neither signed my name thereon, and no act, consent, authorization, or participation on my part was involved in the said transaction. Now, a similar kind of document was signed.
This Roming Liana is the one who has got an NIA case for arms smuggling, I think.
It's possible, my lord.
Yes, no, it's what possible. I think there is a High Court appeal by the NIA. There's an appeal. I think it's still pending. C. Zoram Chana is the counsel for the NIA, I think. If I'm not mistaken.
Now, that is one document, my lord. And the second document signed by H.L. Samuela. Similar thing was signed by H.L. Samuela, my lord. They said they had no involvement in the conversion.
All of them, or only these 2?
No, only these 2 and Ram Fangzawa, the 3 of them. And also, my lord, there is a document made by the village council president. The village council president at page number 176A, my lord. This is the English translation.
So 186A?
176A. Says like this. With regard to the acquisition of land belonging to Puro Minglian at Vivacon, Aizol by the Indian Air Force within the Lengpui area, the village community has not received any written or oral notification whatsoever from the government, nor has there been any consultation, discussion, or engagement of any kind with the community. We are also unaware that a social impact assessment was being conducted. Furthermore, I hereby state that the community has not issued or granted any no objection certificate. The reason this document, my lord, is significant is because if I take your lordships to the rest of the records, your lordships will see that the authorities, they had claimed that no objection was taken from the local people and all that. So that that claim by the state government is directly contradicted by this document of the village council president. Now, the first point, my lord, we are trying to stress on this is because it involves a huge amount of public money, my lord, 199 crores, around 199 crores. Now, when the issue involves that much amount of money, my lord, and it appears to us, my lord, that there are certain elements of forgery and fraud involved in the way the LSCs were handled.
So the money should have gone to the actual landowners.
That is one. That is one. If it is to be acquired, my lord, the acquisition has to go to the landowners. The second, my lord, is this. The second is that, my lord, the provisions of the Land Acquisition Act, particularly Section 40 of the new Act 2013, has also 40. Now 40 deals with urgency, my lords. Now in case of urgency, acquisition can be done at a speed, at a certain speed. But my lord, as per a Supreme Court judgment of 1975, if I'm not mistaken, I'll give your lordship the judgment, the year. It is provided, my lord, because in the old Act also there is a provision for urgency. There has to be some sort of reason given when there is an urgency. In the present case, my lords, since 2019 steps were taken for acquisition, and suddenly in 2025, the government, the district council, the district commissioner, and also the Land Revenue and Settlement Department, they claim that there was a certain urgency, and they have not given the reasons why there is urgency, and they have speed up the acquisition, my lord, and they have acquired the lands. Now, given these facts, my lord, our humble submission is when it involves a huge amount of public money, how can the act be diluted in such a manner as it has been done in the present case?
Yes, madam.
My lord, I'll have to seek instructions. And my lord, in this case, the
Why
aggrieved
did the,
party
why,
should be.
why did the money go
My
to
lord,
this roaming Lena and this Henry?
my lord, it
Where
seems
is-
there is some sale deed which has been annexed.
Where is Henry's name? Where does Henry come in? And Henry, I think, if you look at your excise case records, though I need to say more, I think you'll have to do some digging. I don't know if he's the same person.
Most probably, my lord.
There is something very funny here. For the simple reason that when land is acquired, the money has to go to the landowner.
My lord, an agreement was a sale deed or an agreement was.
Those sale deeds are all, they are not registered sale deeds. And all under section 17 of the Indian Registration Act 1906, I think, anything above 100 has to be registered. None of them are registered. And now these landowner, one of them is saying, three of them are saying that we don't know anything what has happened to our land, how it became LSC. So someone, basically what they're saying is, respondent number 14 has cheated us out of our money with the help of the government.
My lord, there is no such statement by the
No,
landowners.
it's implied. It's implied. It's not
If
so
they are
bad.
really aggrieved, my lord, they can come forward and file a suit, my lord.
File a suit. You're in such a hurry to give away 199 crores, why should they file a suit? Unless you say that they are disputed questions of fact. Are they disputed questions of fact as on date? You see, it says here, I had no involvement whatsoever in the process of conversion or alteration of the said land from a village council to a land settlement certificate. Further, with regard to any application made for such conversion or any transaction relating to the purchase and sale of the said land by roaming Liena, including so and so, I have neither signed my name. So he says that he has not sold the land. Anyway, today is the first day we'll issue notice,
All right, my lord.
as always do. But we need a set of answers from you all. And in the meantime, one thing, another aspect of the matter is, if those LSEs had been given as security for some loan or something, because respondent number 14 has said that it is with the IDBI.
Yes.
In that case, that land could not have been acquired at all.
Yes.
The bank could have the first charge on the said land. It was it was encumbered land. So how come? What is going on? You have to find out.
All right.
Okay, right. Heard Mr. Joseph Lalchanhima, learned counsel for the petitioners, that is the Citizen Alliance for Truth and Justice (CATAJ), which is a registered society having registration number MSR 1729 of 11/11/2024. And Reverend Zaid Arzawa. The petitioners have brought into question the acquisition of approximately 110 acres of land at Lengpui village for establishment of an Indian Air Force administrative establishment for a sum of rupees, where is that? Page
Around
that
190.
forward? Huh? Page
My lord, at page,
116.
yes,
For a sum of rupees not 116, it is, sorry, 160 or what?
168,
Huh? 168.
yes,
168. Amounting to rupees 1,98,78,55,155. And disbursement of the said amount to the respondent number
14 and 15.
14 and 15 who are not the landowners. Pusta. The case of the petitioners is that seven LSEs had been acquired by the state government, whose names and their LSE numbers and the compensation amount payable to them along with interest, etc., are as follows. You make a chart, huh? This is in terms of page 168. You take column 1, column 2, column 4 and column 13. Okay, only 4 columns. Okay. Next. The above 7 LSEs had been acquired had been acquired under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, hereinafter referred to as the Act. Through award number F full stop 14011 /327 /2025 DC bracket capital A /LNB dated
24/7.
24/7/2025.
5.
Interestingly, the landowners of 3 of the LSCs, that is H.L. Samuela, Aram Fangzawa, and
KLL Dua.
huh?
KLL Dua.
Oh, you put KLL Dua first. Huh? KLL Dua will be K full stop LALDUHA, comma, then HL Samuela, 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 and Aram Fangzawa will be RAMFANGZAUVA. Have made certificates to the effect that they did not know how their land covered by village council passes,
Yes, initially village council passes.
had been converted into land settlement certificates. And that they were not involved in any transaction involved in any sale deed or transaction regarding their land with the respondent number 14. Full stop. Now, full stop, comma, who has received
Page 175A, my lords.
who has received, how much has he received in total? Roaming Lena?
Roaming Lena, my lord, around 70 crores, my lord.
They'll say around, give me the exact figure. What
My
is
lord,
this?
1 minute, my lord, because I have to add, my lord, 324. Okay, 699.
Who has received 69, 99, 60, 000. While the respondent number 15 had received 117, 90, 26, 341. Next para. The petitioner's counsel has taken us through the 7 LSCs which are in the names of the 7 LSCs, take us through the 7 LSCs and the sale deeds, showing that the 7 LSCs have been sold to the respondent number
14.
On 9/5/2005. However, none of the sale deeds have been registered as per the Indian Registration Act as amended for the state of Mizoram. Full stop. It is interesting to note that don't say that. The petitioner's counsel has also taken us through a document purportedly made by the landowners in favor of respondent number 14 on Two 2019, authorizing the respondent number 14 to deal with the to do whatsoever was necessary for getting payment of compensation for acquisition of their lands. We have also been taken through a letter dated 25/9/2019 issued by the Additional Deputy Commissioner (E, Aizawl District, Aizawl) pertaining to the meeting minutes held in the office of the Additional Deputy Commissioner on 24/9/2019 in connection with acquisition of land by the Indian Air Force at Sipir and Lengpui. Full stop. Next para. We are we have also been taken through where is that IDBI thing?
My lord, that's in the that's at page number 170.
170.
170.
170. An undertaking dated 18/7/25 made by the respondent number 14, which is to the effect that he could not produce the original land settlement certificates of the acquired lands, as he had mortgaged all the said LSCs in the IDBI Bank Regional Office, Gauhati, to avail of the loans which were not yet liquidated. As such, he undertook that if rupees 30 crores out of 70 crores of compensation were partly disbursed to him, the same would be utilized by the respondent number 14 to clear his dues and redeem all the original copies of the LSEs from the IDBI Bank Regional Office, Gauhati, which would thereafter be submitted to the office of the District Collector, Aizawl. Next para. We are of the view that the state respondents would have to clarify as to how compensation could have been disbursed to the respondent number 14 and 15 when they were not the landowners, inasmuch as the sale deeds were not registered. Further, 3 of the landowners have made certificates which are part of annexure 32. No,
30.
which are annexure 30, 31 and 32.
Yes.
Annexure 30, 31 and 32. Denying that they had converted their village council passes into LSEs or had sold their land to the respondent number 14. What is the basis for giving the compensation amount to the respondent number 14 and 15 would have to be clarified by the state respondents. That's all. Issue notice, returnable in 4 weeks. Ms. Zaire M. Sang, please CGC accept notice on behalf of respondents number
1 to 6.
1 to 6. While Ms. Linda L. Fumble, additional AG, accepts notice on behalf of respondents number
7 to 12.
7 to 12.
14 to 16 will take steps.
Petitioner will take steps for service of notice upon the respondents number 13 to 16
Yes.
by speed post and usual process within 2 days. List the matter on, give it.
25th of August.
This list the matter also, by which date the respondent should file their affidavits.
Obliged.
For admission, item number 2.
May I please, Your Lordship?
Yes.
Lordship, my senior Mr. S.K. Mehdi has some personal difficulty. If possible, matter may be taken up on Friday, Lordship.
Friday?
My
Yes,
lord, a similar matter is pending before the principal seat at Gauhati, which is writ appeal number 320 of 2023, and which is fixed for hearing on 12 August. So this, if this can be taken up after 12,
let it come up on Friday. On Friday, mention it, we'll do it again.
my lord.
Okay. So he's saying that on 12th August there's a similar matter. Is it correct?
Yes, Lordship, yes.
Then let it
Okay.
come up after that date.
No problem, Lordship.
Yes. Okay, right. Adjournment prayer has been made on behalf of Mr. S.K. Medi, learned counsel for the appellant. The matter pertains to payment of interest under section 34 of the alia Act 1894, which has been challenged by the railways on the ground that they were not heard before the learned reference court. Correct? Oh, before the learned single judge. Before the learned single bench. They are not heard before the learned single bench. Next para. Mr. Lalchan Liana, learned counsel for the respondents number 4 to 11. And before that, learned AG, additional AG, Ms. Linda L. Fambol and Mr. Lalchan Liana, counsel for the respondents number 4 to 11, submit that a similar matter, that is WA 320-2023,
My lord.
is to be heard in the principal seat on 12/8/2026.
My lord.
Accordingly, list this matter on after that date.
And
14th of August.
My lord, I have not been served a copy of the writ appeal by the appellant.
The appellant's counsel shall, within 3 days, furnish a copy of the appeal to the counsel for the respondents number 4 to 11.
Much all.
Obliged, Your Lordship.
Item number 3.
Yes, what is your case?
Well, it's the writ appeal is with respect to the tender procedure that
Yes.
has been initiated by PND Department, Government of Mizoram.
PNE department.
PND Department, my lords. My lords, the main issue in this, the outcome of the tender process was.
Is it a two-bit system?
Yes, my lords. Financial and
system.
technical bids, yes.
So in the technical bid, did you qualify the
My lord,
technical bid?
My bid,
Just answer the question.
they disqualified me.
Huh?
They disqualified me.
You qualified.
Disqualified. They disqualified.
Disqualified.
Yes.
Disqualified. So have you challenged that disqualification?
Yes, my lords.
Then that was what happened?
My lords, the disqualification has been upheld by the single judge on the premises that my lord, the whole issue for disqualification was that I was disqualified on the ground that my joint venture agreement was not there, my lords.
And the end of the matter.
My lord, the tender terms did not require
Mr. Counsel,
submission of the joint
Mr.
venture
Counsel,
agreement. my lords.
supposing you are a joint venture, if now to qualify for a tender, what was the turnover required?
14 point,
14 point how much?
14.35, my lords.
14.35.
Yes.
Now, did you, as an individual company, have that qualification?
No, my lords.
End of
My
the
lords, that was the reason we participated as a joint venture agreement, my lords.
Mr. Counsel, when you participate as a joint venture, unless you tell them that you are a joint venture, how will they know that you are a joint
They
venture?
acknowledge me as a joint
No,
venture,
no,
my
they-
lords. My lords, I can show you from the document
No
that they
case,
acknowledge
no
me
case,
as a.
no case.
My lords, let me rely upon a judgment, my
No,
lords.
you can rely upon 20 judgments also. No case.
My lords, the judgment clearly states that.
Now, what is your, you are challenging the respondent number 4 also.
My lords,
On what ground?
they have not, they have not clarified, they have not fulfilled the essential terms of the tender, my lords.
Mr. Counsel, have you read Tata Motors judgment
Yes, my
by
lords.
Supreme Court
Yes, my lords.
and Ronak International?
Yes, my lords.
What does it say?
My lords, Tata intervention is limited, my
It
lords.
basically says that any judicial relief
Yes, my lords.
at the instance of a party who does not fulfill the requisite criteria is misplaced.
But my lord,
That means unless you are qualified, you have no business challenging others, saying that they should have been disqualified. You
But
have
my
got
lords,
no
we are
business.
also challenging that. My lords, we have substantially submitted our bid. It was technically and financially qualified, my lords. My lords, the
No
Supreme
case.
Court judgment also says that essential terms has to be satisfied.
Mr. Counsel, you see, AFCON's decision is very clear. AFCON's decision is what? Who is the authority?
The Penny Department, my lords.
The person who makes the tender.
Yes, my lords.
Their interpretation is the ultimate. Courts should not interfere at all.
My lords, court should not interfere. But my lords, the terms condition for disqualification cannot be beyond the terms of tender. That also Supreme Court clearly
Mr.
satisfied.
Counsel,
my lords.
just show me that. Just show me the
Terms and conditions?
NIT where he is required to have that thing.
Yes.
And you did not submit a joint venture. End of the matter.
My lords, I'll just.
Joint venture.
My lords, joint venture agreement was not at all required by the terms of tender, my lords.
Mr. Counsel, it's very simple. If you say
Yes.
that you have entered as a joint venture company, you have got to prove you are a joint venture company.
My lord, let me rely with this specific.
Yes, where is that turnover page? Turnover.
My lord, the other.
Just a minute, where is the turnover? Don't change the subject.
My lord, turnover requirement in the NIT, my lords. My lord, at page 227. My lords, my mistake. My lords, 223. My lords, it specifies the qualifying requirement, my lords. My lords, the first one is submission of earnest money.
Just a minute. Where is the turnover? 223.
223. Point number 2, qualifying requirement. Point 2, my lords. Average annual financial turnover during the immediate last 5 should be more than 14.36 crore.
And where is the decision of the authorities disqualifying you?
My lords, at page 48. My lords, please acknowledge that they have acknowledged us as a joint venture.
Mr. Counsel, they have acknowledged you as a joint venture, but then you have got to prove that you are a joint venture because you have submitted your bid as a joint venture.
Yes, my lord.
You have got to submit it. You have got to submit and you have got to prove that you are a joint venture. You see, when I say, supposing we ask for candidates. Now there will be some candidates who are scheduled tribe or some scheduled caste or some OBCs. Now when they say that we are submitting our candidature as OBC, we will accept, but then we will scrutinize. Where is your proof of being a OBC? Unless that is there, then you will have to accept.
My lords, on this ground, there is a clear Supreme Court judgment on the same factual metrics, my lords, that in case the joint venture agreement is not required, then it cannot be made as a ground for disqualification, my lords.
You are with
My lords,
reference to the subject, you are informed that upon Zoram venture only. See the signature are not available. So only the lead partner, yes, Zoram Ventures, the lead partner.
Yes, my lords.
The lead partner signed, you did not sign. The others did not sign.
But my lords, the financial
Annual turnover of claim partner Semco Infratech and FT. So these Semco
lords-
Infratech Private Limited and FST Electricals, they are two other entities.
entities, my lords.
Two others. So all joint venture was three.
Yes, my lords. My lords, please note that cannot be considered. It was on record, my lords, with them, but they have deliberately not considered the financial turnover of the other two partners, my lords.
Naturally. You have not submitted a proper venture, joint venture agreement. It's not signed by only one person. It has to be signed by everyone.
My lords-
Now what will happen? Tomorrow if they give you the work, then the others, they will say that we are not part of it.
My lords,
What can be done?
my lords, if that would have been the case, the documents of the other two members would not have been available with the bidding
We
authority,
don't
my
know,
lords.
we don't know. Anything can happen.
My lord, please at least let me rely upon a Mahamineral judgment, my lords. My lords, I will be able to satisfy your lordship that if the terms and conditions did not prescribe submission of the joint venture, that cannot be made as a ground, my lords. Please let me allow my lords to at least refer to that judgment, my lords. And my lords, the terms and conditions which are the essential has to be complied with. And my lords, not only respondent number 4 has not complied with the essential
Mr.
terms of
Counsel,
condition.
you see, that argument will not work.
Let me first.
That argument about the respondent number 4 not having the essential conditions or qualifications will not work.
My lord, let me allow to satisfy myself as an appellant, my lord. My lords, may please refer para number 19, which is at page number 12. Madam, let me brief you about the fact of this case, that in this tender also joint venture agreement was not required to be submitted. So they were disqualified on the grounds that their past experience cannot be taken into consideration because they have not submitted the joint venture agreement. It's a similar facts of this matter, my lords. My lords, I'll read para 19. Clause 5D merely state that the appellant would be entitled to use the past experience of the previous consortium JV in the event its proportionate share is defined in the JV agreement, failing which the past experience shall be attributed to the lead partner. The clause did not mandate submission of the joint venture agreement itself to satisfy the criteria. Appellant had relied on the work execution certificate issued by the MSMC, which in no uncertain terms states that the appellant had 45% in the JV consortium named Hindu Mahamineral LLP and successfully executed similar work of a volume larger than the required under the clause. The certificate also mentioned the JV agreement had been submitted and was in the custody of MSMC. Well, let's come to subclause 3, my lords, next page. Condition in the NIT must be clear and unambiguous. In the event tendering authority insisted on furnishing the JV agreement alone and no other document as a proof of proportionate share of the bidder to avail the previous JV experience as prior qualification, it should have been spelled out clearly in the NIT. Having not done so, the first respondent cannot thrust the responsibility on the appellant to seek clarification, submit such document. As clause 5D does not require submission of the JV agreement itself to establish proportionate share in the JV, whose past experience the bid is seeking to use, non-submission of such JV cannot be a ground to disqualify the bidder for submission of incomplete document in terms of clause 8.1 of the NIT.
No, you see, the issue is out here slightly different. Out here, there was non-submission of the agreement. You have submitted an agreement signed by one person.
Malus, that was not required. So, Malus, the terms of tender is clear that the JV agreement is not required. So, that cannot be made as.
Show me. Where does it say that not required?
Malus, because
where does it say in the agreement?
I'll rely upon the single bench judgment, which has analyzed this aspect and has given the conclusion that there is no stipulation for submission of JV, Malus.
No. You show me from the advertisement.
From the.
From the advertisement.
Oh, my lord, they,
from the NIT.
my lord, NIT nowhere states JV is required, so my lord, I cannot show you that, but that ground has been analyzed by the single judge and has,
You see, you are challenging the single judge order. So we don't have to accept
my lord,
everything.
my lord, it's not written in the NIT, so I cannot show to your lordship.
Okay, I'll hear the other side now.
Yes.
Yes.
Your
His
Lordship-
basic case is that, is it a requirement in the NIT to submit your JV agreement?
Yes, Your Lordship. Your Lordship, if I may refer to page number 18 of the writ appeal, Your Lordship. That
18?
Yes, Your Lordship. Page number 18 of the writ appeal. Your Lordship, in this, there is pan number 30 of the judgment, impugned judgment order dated 29/5/2026. There is an observation made by the learned single judge, wherein in pan number 30, Your Lordship, if I may read, it says, in the present case is... Page number 18 of the writ appeal, Your
Yes,
Lordship.
yes.
The impugned judgment order, pan number 30, it says...
30? 30?
30.
There's
Impugned
3.10.
judgment, in the impugned judgment order, Your Lordship, that is attached in the writ appeal.
The impugned judgment.
Yes, Your Lordship.
Which page is that? You're looking at the
Roman numerical 18, Your Lordship.
page number.
18. 18, Your Lordship.
No, there'll be a running page here in the main writ appeal. There'll be a writ. What page are you talking about? Where is your judgment?
My lord, at the very beginning, my lord, with the Roman numbers. It's with
Not
the Roman
that-
number.
Where is the other one? We cannot tick the certified copy. Where is the other copy of this certified copy?
My lord, only single copy has been annexed in the beginning.
That's not
my
the
lord.
way to do it. You put the certified copy in the first page. We have got to make marks on it wherever we filed relevant. We cannot
Apologies,
destroy
my
a
lords.
certified copy. That has to be part of the other copy has to be there.
My
Part
lords,
of your
will
thing.
definitely do that, man. My lords, will do that.
Definitely, you are supposed to do it. Yes.
Lordship, in pan number 30, it says, in the present case, as may be noted, the petitioner failed to demonstrate its financial soundness to the satisfaction of the tender authority, and the decision taken could not be said to be arbitrary, since...
Just a minute. Para?
Para 30, Your Lordship, 30.
Okay. Yes.
The petitioner failed to demonstrate its financial soundness to the satisfaction of the tender authority, and the decision taken could not be said to be arbitrary, since the joint venture agreement submitted by the petitioner was found to be with only one signatory. Therefore, when the petitioner did not qualify in the bidding process, it cannot be said to have any legitimate grievance in the selection of respondent number 4, whose tender was otherwise found to be valid. Having come to the conclusion, further reference to the authorities relied upon, Your Lordship, this Maha Minerals has already been relied upon, the Maha Minerals which has been relied upon, the Learned Council has already been relied upon in the writ petition as well. Further reference to the authorities relied upon by the parties is found to be not necessary. In the result, the writ petition is found to be without merit, and the same is dismissed. Likewise, that is all, Your Lordship. Now, Your Lordship, as to the I would like to state that, Your Lordship, at this stage, the current project is of a vital public importance because, Your Lordship, the existing transformer, which is supplying electricity to approximately 1/3 of Aizawl city, is presently operating under excessive load, and it is at the brink of failure. Now, the project in question actually specifically provides for the installation of higher capacity transformers. And secondly, Your Lordship, the first installment of funds have already been released to respondent number 4, and mobilization of advances amounting to 4.5 crores already been disbursed. So, Your Lordship, a third party right has already been created. Thirdly, Your Lordship, I would like to state that if, Your Lordship, any order staying the implementation of the impugned judgment order would not only jeopardize a project involving in substantial public funds, but it will also seriously prejudice.
Those are the normal things.
Yes, Your Lordship.
In black and white, you all have awarded the work order to...
Yes, Your Lordship.
When did you award the work order?
Your Lordship, this was... Your Lordship, there was a submission of mobilization advance bill on 1/7/2026, Your Lordship. That is the copy that has been given to me. And there was a meeting minutes also of 18/6/2026, wherein it was emphasized on the public importance of this certain project, Your Lordship. And the project is supposed to have commenced and also completed by May 2027, Your Lordship.
May 2027. May
Yes.
2027?
Yes, Your Lordship.
Okay.
Yes, Your Lordship. The funding was under the condition that the project will be completed within 18 months. So 6 months have already lapsed because of the petition itself. And now already, Your Lordship, we are already, if there's another stay, that would actually impose another further delay, Your Lordship.
So earlier there was NIT. I think there was only one tenderer. Correct?
Yes, Your Lordship.
It was the respondent
Yes,
number
Your
4.
Lordship. Yes, Your
So
Lordship.
you all had another NIT, then he came. into
Yes,
the
Your
picture.
Lordship.
My lords, with respect to the point that my lord has raised, whether the NIT stipulates whether the joint venture agreement is required or not, my lords, the respondent has not uttered a word about it. But my lords, may I satisfy your lordship that NIT nowhere mention about the JV agreement requirement. My lords, may please refer impugn judgment, Roman page number 15.
Where is the NIT page? This is for the state where least bother about you making a profit.
My lord, NIT is at page number 216.
Where is the disqualification of the respondent, the appellant page?
My lord, page 48.
Page 14? Where is the document disqualifying the thing, the technical bit of the appellant?
My lords, page 48.
48.
48, my lords. That is annexion 3, my lords.
We'll take it up again on Thursday. This is the matter on Thursday.
Yes, Your Lordship.
Item number 4.
May I please, Your Lordship?
Yes.
This IA is for condonation of delay in filing
Okay,
the.
right. What is your name? What is your name? What is
KK
your-
Medhi.
Huh?
KK Medhi.
Heard Mr. KK Mehdi, learned counsel for the applicant who submits that there is a delay of 159 days in filing the appeal against the order dated 6/2/2026 passed by the learned single judge in WPC number 118 of 2024. Issue notice returnable in 4 weeks. Applicant to take steps for service of notice upon the respondents by speed post and usual mode within 2 days. List the matter on give a date.
Much obliged.
5th of August.
At the boss. I mean, DBA judgment.
from part 2, item 7 and 8.
Yes.
Your Worship, these matters may come up next week, Your Worship.
Okay. On the why? What is the matter about?
Yep, this is regarding regularization of the contract services of the petitioners working under ribbons. So,
Okay, on the prayer for adjournment made by Mr. R. Malhotra, which is not objected to. Any objection? It is not objected to by the other side. Leaves the matter in the next week.
May I please, Your Lordship, I beg to mention one unlisted matter, that is WPC 103 of 2026. This writ petition relates to a tender for constructions of hospital. However, Lordship, the same cannot be
Taken up by me.
heard yes, Lordship. So if it may go to
Okay,
code number 2.
Okay, code number 2.
Oblige.
If I may seek Your Lordship's indulgence, in mentioning item 15 of part 2, if it can come up this Thursday, my Lord, it's a small issue.
Which one?
Item 15 of part 2. My application for setting aside ex parte order was rejected by the trial court, so I filed the appeal
Okay.
this Thursday, my Lord. I've taken the consent of the other parties.
Item 15.
Yes, my Lord, of part 2. Oblige, my Lord.
My Lord, may I make a mention of item 2, part 2. I'm the petitioner. I'm appearing on behalf of Mr. C. Zoramthana. He has some personal difficulty. If the matter may be taken up after a week.
Yes. 1 and 2 are joined.
Yes, my Lord.
Yes, Mr. Ramdawa.
Lordship, I have no objection.
On the prayer for adjournment made by Mr. C. Zoramthana, this is the matter. After a week.
For motion, item number 1.
My Lord, this matter relates to the illegal repossession of a vehicle by the...
What is illegal about it? You have
It
not
is-
paid you have not repaid your loan.
Yes, I admit that I have repaid my loan due to...
You see your prayers.
Yes.
Can this be done in the writ court? You see your prayers. I think you go for what is wrong? You have not paid your loan.
My loan
There
is
was
not-
an accident.
Yes.
That you cannot. Why should the finance company suffer because of your accident? That is your problem, not their problem.
Well,
If you get sick, it is your problem, not their problem.
while repossessing my vehicle, it was done without my knowledge also.
Naturally, if
Yes.
you are not going to allow it to be done if it was within your knowledge. They must have done it while you were sleeping or something like that. They must have stolen it according to you.
Then insurance was also claimed without my knowledge also,
Huh?
regarding the insurance also.
Look, Mr. Kaushik, it's a simple thing.
Yes.
You have asked for finance for your car. You have been given that car loan. You are not repaying your car loan for whatever reason. They have got a right to reclaim it. What is wrong?
Because, my Lord, there is a violation of RBI master circulars.
What does it say? Let us see your agreement with the finance company.
The agreement copy was not furnished to us.
Huh?
The agreement copy was not furnished to us. On page number 28 of my writ petition, 27 is the master direction issued by the RBI on...
How is the writ petition maintainable, Mr. Counsel?
Because there is a violation of Article 21. Because I
How?
am. This is the.
How is 21 violated?
This is my
Livelihood.
livelihood. Yes. I
So,
am.
yeah, how is your livelihood violated? You're cheating them.
I am
You
not
cannot,
cheating.
a thief cannot say that my livelihood is violated.
I am not cheating
Supposing
them.
a thief gets caught, he says, no, unless I steal, I will not be able to eat. Then what happens?
I am not cheating them because as soon as the vehicle faced accident, I had approached them, then asked for.
Yes, madam, anything? Yeah,
Yes, Your Lordship, I would like to raise the maintainability of this writ petition because my first point is that, Your Lordship, the respondent number 5 and 6 are private parties, and unless the respondent number 5 and 6 are discharging public duty, writ cannot lie. And with regards to the violation of fundamental right, Article 21, NBFC is not a state. And in this...
no, but isn't the writ maintainable against a private party also?
And Your Lordship, with regards to the FIR, remedy is under Section 156 Clause 3 of CRPC. And for the rest...
You filed an FIR?
Yes,
Yes.
I have filed an FIR.
Go there.
And vehicles, with regards to the vehicle seizure and insurance claim, the appropriate remedy available is as stated under Section 17 of the SURFICE Act 2002 is Debt Recovery Tribunal.
My Lord, a similar case has been decided by the High Court of Uttarakhand on 2nd April 2026. So if you allow me.
No copy for your...
Yes.
No copy.
Your Lordship, I also have one citation with regards
Okay.
to the maintainability.
Yes, two writ petitions were clubbed together in this case. Then may I read out from the para 2. In writ petition, MS number 2032 of 2023. The petitioner Mohanlal, a transformer by profession, is the registered owner of a goods vehicle bearing registration number UP 266199, which was financed by the respondent number 3, Indostar Capital Finance Limited. The respondent sanctioned a loan of rupees 31,40,848 for purchase of the said vehicle, which was repayable in 66 equated monthly installment. As per the petitioner, he has already paid a sum of rupees 14,66,850 towards the loan amount. It is the case of the petitioner that only an amount of rupees 1,84,030 remain due as on 22/6/2023. However, an additional sum of rupees 47,994 has been arbitrarily aided by the respondent without justification. On 25/6/2023, while the vehicle was on a commercial consignment, it is alleged that the recovery agents of the respondent forcibly intercepted the vehicle, removed the driver, and repossessed the same without following due process of law. Despite subsequent representations and issuance of legal notice, the vehicle was not returned. Then, my Lord, on page para 10, on page number 5 of the judgment, having considered the submissions advanced by the learned counsel for the parties and upon perusal of the materials brought on record, this court finds that the central issue arising the determination is not merely the existence of contractual relationship between the parties or the quantum of outstanding dues, but the legality, fairness, and procedural propriety of the manner in which the respondent financial institution has proceeded to repossess or attempt to repossess the vehicles of the petitioner.
Tell me, how much loan did you take?
37 lakhs 43,368.
How much have you repaid?
The exact amount I have repaid is not.
You don't know?
Yes, I don't know exactly.
Then why don't you know? Yes, how much has he paid? You also don't know.
The principal outstanding is 20 lakhs 5,614.
How much?
My outstanding is 20. Principal outstanding is 20 lakhs and 5,614.
That is on the principal amount. Then what
Yes.
about the interest? How much are you liable? Interest?
The penal charges incurred upon us is 29,861.
29 lakhs or 29,000?
Yes.
How can it be?
Then the total outstanding is 23 lakhs 34,811.
Who has given you this figure? The respondent has given you this figure.
Yes.
How much has he defaulted, madam? Please get the facts. And the facts will help us decide this way or that way. Both of you. Classes for the party shall find out the exact amount
Yes, my lord.
payable by the petitioner to the financier. They shall also inform this court about the amount of default.
The amount of default. Yes, my lord. On page.
On payment made by the petitioner. This is the matter on Thursday. Get the figure by then.
Yes, my lord.
Yes, some decision you were saying. Where is your decision?
Your Lordship, 2022 5 SCC 345. Your Lordship, since this is a private contract dispute between the petitioner and the respondent number 2, the respondent number 2 is NBFC, which is a private bank, and it is not state under Article 12 and writ petition.
This Phoenix Arc Private Limited. This one?
Yes, Your Lordship. Para 11 and 12. Your Lordship, at Para 11, it was observed by this court that the court, while exercising its jurisdiction under
Para 11.
Yes, Your Lordship. Page 357.
It starts as In City and Industrial Development.
Yes, Your Lordship. In City and Industrial Development Corporation versus Dosu Ardeshir Bhiwan Diwala. It was observed by this court in SCC Para 175, Para 30, that the court, while exercising its jurisdiction under Article 226, is duty bound to consider whether the petitioner has any alternative or effective remedy for the resolution of the dispute. And Para 12, in Kanai Yalal Chand Sachdev, after referring to the earliest decisions of this court in Sandhana Lot versus National Insurance Company Limited, Surya Dev Rai versus Ram Chandra Rai, and SBI versus Elite Chemical Laboratories, while upholding the order passed by the High Court dismissing the writ petition on the ground that an efficacious remedy is available under Section 17 of the SURFICE Act. It was observed that ordinary relief under Articles 226.
Madam, SURFICE Act is for loans given by the bank.
Yes, Your Lordship.
Is it
Yes.
applicable to this case?
Yes, Your Lordship.
How do you say it's
because
applicable?
this is a pure private dispute of.
Then, madam, you should have gone to the DRT. It was you were the ones who wanted the money. You see, for for applying the SARFAESI Act, it is the person who loans the money that goes to the DRT for recovery of the money. You'll have to do some more reading. I think you all have not read enough. Please read. Burn some midnight oil. I don't know. You seem to be in a sticky wicket. This is a writ court. Some right of yours has to be violated, not livelihood. That is neither here nor there. Livelihood, you can always become a farmer. So that is not, no one stopping you from doing that or this. It doesn't mean that you have to drive a vehicle without repaying the loan. So how many months has he defaulted, madam?
Your Lordship.
Please get those facts, okay, by Thursday. This is the matter.
Your Lordship,
Next.
Item 2.
Your Lordship, if I may, I am only representing the respondent number 3 and 4, which
Who
is
is
the
3 and 4?
police.
Police?
Yes, Your Lordship, the SP, Aizawl district, and the officer.
Okay,
The rest are private respondents. So,
okay, you please find out. Yeah. So most probably it will be dismissed on the next date, but you can try your luck. Do some reading.
Yes, Your Lordship.
I don't think this is the right, with the prayers that you have made, I don't think this is the right forum. Think about it. Thursday.
Yes,
Next.
my lord.
Yes, what about this?
This is an application for release of area of pension, which is to be released to the petitioner from the central government share.
What? Central government share?
Yes. Mizoram State Social Welfare Board was established. Then the finance is 50-50 share between the central.
Is it a pensionable post?
Yes.
Who is appearing for the board?
And for respondent number 1 to 10.
How can pension be given state share, central share? This is the first time I've heard of this.
Yes.
It being paid from two different sources. The post? Is it a post created under the state government or under the central government?
It is created by the state government.
If it is a post created by the state government, it has to be paid by the state government.
But the pensioner benefits was the central on page number 42, my lord, the Central State Social Welfare Board has a proposal for extension of
It is a board, it's
yes.
a board.
Yes, yes.
Please read.
Yes, on page 42.
Yes.
The chairman, all state social welfare advisory boards.
Yes.
Yes, extension of pensionary gratuity benefits to the employee of the state social welfare advisory boards.
They are willing to bear 50% expenditure.
Yes.
Of state government share. That's all.
Yes.
Where is the central government saying that they will bear your pension? there is, central government has got nothing to do.
In Para 2, it was earlier thought that a decision in the matter could be taken only after all the state governments had conveyed their concurrence. But since the matter is being delayed unduly and the employees of the state boards
Where are you reading? Which page are you reading?
Page number 42, my lord.
Please tell me the page also, then we'll all be the same page. Page 42, yes?
Yes. In Para 2, the
Where?
true type copy is in page 42A. It was earlier thought that a decision in the matter could be taken only after all the state governments conveyed their concurrence. But since the matter is being delayed unduly and the employees of the state boards are being denied of these benefits for long, it has been decided that the pensionary gratuity benefits may be extended to the state board's employees with effect from 1st April 1979. In case where the state governments concerned have also agreed to share 50% expenditure in accordance with the agreed pattern. In cases where the CPF benefits is already in effect, the employees may be given the option where to remain under the CPF or to be up for the pension scheme. Such an option should be exercised and be treated as final with the period of 6 months of the introduction
What
of
is the CPF? What is CPF?
Contributory Provident
Then,
Fund, yes.
now, you have opted for which one? You have opted for the CPF or you have opted for the pension scheme? Which
Pension
one?
scheme, yes.
You have opted for the pensions. Now, where does it say that the central government will pay 50%? Where
Yes,
does it say?
50%.
This is a board. It's like your KVI board, it's like your ZITCO, like that. Why should the central government pay your pension, half your pension? Who is the appointing authority? Central government.
The Mizoram state.
Then?
My lord, may I kindly bring you to page number 40.
40. There's nothing, Mr. Counsel. You have got to show us how the central government is the thing. You have not been able to show. Why should central government pay 50% of your pension?
Yes, on page number 35 is the rules governing composition and functioning of the State Social Welfare Advisory Boards with latest amendments for record and use. In continuation of that page, this is a rules. And on page number 40.
Mr. Counsel, this is a board constituted by the state government. You will have your own bylaws. You will have your own constitution. What does it say? What does your bylaw say? What does your constitution say? You've got no idea. I think you are under a mistaken belief that the central government has to pay 50%. There's nothing like that. Never is there. You see, pension, it's either paid by the center for central government employees or it's either paid by the state for state government employees. If they are boards will pay. And if the state government says they pay a share of the board's thing because they make up the board of governors, usually a board of directors. If they say they are part of the pension, that's a different thing. There is nothing to show that the central government will pay 50% of your pension. That also, you are not even a state government employee, you are a board.
Yes, my lord, on page 40 in the rules 12.
Page 40.
Yes. Budget.
40. Page 40, yes?
Yes. Rule 12.1.
Huh?
Yes, budget.
Yes?
That is a rule 12.1.
Huh?
The board shall in each year submit to the Central Social Welfare Board its revised budget for the current year and its budget.
Correct, its budget it will give. Budget
Yes.
will give. But then you see, the payment is to be made not by the central government.
In the last two lines. The
You see, it's
expenditure-
like this, Mr. Counsel.
Yes.
Mizoram government also makes a budget
Yes.
and gives it to the center. And center gives them money. It doesn't mean that If pension is not given to one person, that center has to give him pension. No. That's not the case. You please come to page 40, the top part, 7, 8.
Yes.
Have you got one? It says 6, 7, 8, page 40.
Yes.
The employees of the state board will be governed by the state government rules in terms of their service conditions. The state board will also follow the state government rules in case of other financial and administrative matters. There's nothing to do with the center.
My Lord, in the Rule 12, the expenditure incurred on the establishment of the office of the state board will be equally shared by the central
Mr.
government.
Council,
Then
that is for the, you go against the board. You tell them that you've got to give me the entire pension. There's nothing for the central government to pay you 50%. You withdraw this writ petition and you file against that your board, saying that you have to give full pension. But as I find it, there's nothing. If government has said that they will pay 50%, that's all, state government. And if they paid 50%, you've got no case. So I'm giving you 2 minutes, you take a decision, either I dismiss or you withdraw, that's all.
My Lord,
Right. Heard,
please,
Mr. Huh?
one submission. The petitioner was retired on 2019. Then after that, the budget was submitted to the Central Social Welfare Board, then which included my area of pensions.
Heard, Mr. I'm dismissing your case. No case. You see, please, when you do a case, please read. There is not one document showing that the central government is liable to pay you your pension. You are not working under the central government. Just because the state board is being given money by the central board does not mean that the center is liable for your pension. Amongst people like you in the board, how many persons have retired? You are the first one to retire or what? From the state board that you retired, how many persons were there before you who have retired? Any idea?
Yes, my Lord.
What? Yes or no? Is there any persons who have retired before you from the board?
Yes.
Who? Who has retired? Please ask them whether they are getting 50% of their pension from the center.
My Lord, one submission, please. On page 64, a revised budget estimate for 2018 to 19 and budget estimate for 2019 to 20 for the state board establishment was submitted to the Central Social Welfare Board. Then they informed the chairperson,
Mr. Council, please understand. You're not understanding at all. Right, I've heard enough. No point. You're not trying to understand. You're not understanding also. Just arguing without. Please try to understand. I'm trying to help you. You're not understanding. You see, like Mizoram government has got no money to pay its various officers and everything. What it does is that it makes a budget and gives it to the center. Center allocates budget to the state.
Yes.
Similarly, your state board asks money from the center to give them budget. The budget is given. That does not mean just because they give budget to the board, state board, that they are liable to pay you your pension. The pension has to be paid by the board, not by the center.
Yes. My Lord, may I be allowed to withdraw the petition?
You see, like I said, if there are persons who have retired before you, which you said they are, you talk to them, ask them, from where are you getting your pension? And then you apply that logic, you apply that.
Yes, my Lord.
You'll get a clear picture from there.
Yes.
Right, heard Mr. Health Welfare Chong to learned counsel for the petitioner, who prays that he may be allowed to withdraw the writ petition. Praise the Lord. Writ petition is dismissed as withdrawn.
You give me liberty, my Lord.
With liberty, but not in the same subject matter center.
Yes, oblige your lordship.
Okay, we will have to withdraw the writ petition with liberty as prayed for. Huh?
Yes.
You make his prayer for prayer. Yes.
For admission, item number 3.
Item 3. Yes.
Yes, Lordship, we have not received any copy of the appeal memo yet.
Yes. What is your case?
In a nutshell is, I'll just place the facts before my lord. Now, the suit land was part of the petitioner, the appellant's father-in-law's land. And that LSC was given to the appellant's father-in-law in the year 1969. Now, in 1998...
No, just tell me, the land is in whose name? The LSC is in whose name?
The LSC is in the petitioner's husband's name.
Appellant's husband's name, you mean?
Yes.
Appellant's husband's name, okay.
Yes. And after the appellant's husband passed away in 2016, the appellant applied for an heirship certificate, which was disputed by the sole respondent. On the basis of an unprobated will, the will was made in the year 1998. Now, my lord, kindly come to page Roman 16. This is the conclusion of the... My lord has it?
Yes.
Now, paragraph 14. Though section 29, subsection 8 of the Mizo Marriage, Divorce and Inheritance of Property Act of 2014 states that probate of a will must be made within 5 years from the death of the testator. In the instant case, in Hunloram Semnathurotia was not probated. Though it is true that the above mentioned section so-and-so stated that the will must be probated before the expiry of 5 years, however, it does not mention that if a will is undisputed by the surviving heirs of the deceased, the same must anyway be probated. So, my lord, I just don't understand this kind of construction.
Where is the LSE?
That's it, page 18.
Kelaldin Liana. Luaya. No, Liana. What is this? Liana.
Laldin Liana. And his father's name is Kelal Liana.
Okay. So this property has been given to the respondent?
No.
To whom?
By the impugned order, yes.
By the impugned order to the respondent.
And now, my lord, there's a crucial fact. Now, this page 18, the LSC was given to the appellant's father on the basis of an heirship certificate that was granted to him.
You said appellant's husband. Kelaldin Liana is the appellant's father. Appellant's husband or what is he?
Husband.
Appellant's husband. Then appellant's husband died. And now the land has been given to?
The land has been dealt with in accordance with the unprobated will.
No, so this it is Laldin Liana's land. It is no one else's land. They have children or not?
No children.
No children.
So, my lord, there's another crucial fact. Now, this LSC in favor of the appellant's husband was given in terms of the heirship certificate. That's at page 17.
Page 17.
Yes. Annexure 4.
Brother Kelaldin Liana.
Now this heirship certificate has never been challenged, and even today it continues to stand.
Okay. Yes, madam, you are appearing for?
I'm appearing for the sole respondent, Lordship.
Sole respondent. They are saying that you have not given them a copy of the appeal. Is the first time?
Yes, yes, my lord, I'll furnish it within this week.
Okay. Right. Heard Mr. Laldev Haka, counsel for the appellant, who submits that by the impugned judgment and order dated 18/12/23, passed by the court of the senior civil judge Aizol in airship case number 1664 of 2016, the land covered by LSC number 36 of 1969, which was in the name of the appellant's husband, has been given to the respondent on the basis of a unprobated will executed by by the appellant's husband.
No, by the appellant husband's mother.
By the appellant's husband's mother. The further case of the appellant is that the LSC number 36 of 1969 had devolved upon the appellant's husband on the death of his father, while heirship certificate dated 27/11/2000.
2001.
No, what is the 2001? 2001.
Yes, my lord.
27/11/2001. Admit the appeal, call for the TCR, issue notice, returnable in 4 weeks. Appellant to take steps for service of notice upon the respondent. Issue notice, returnable in 4 weeks. Miss
Lal Ropari.
Lal Ropari. Don't say returnable in 4 weeks, just say issue notice. Miss Lal Ropari submits that she accepts notice on behalf of the respondent. The counsel for the appellant shall furnish a copy of the appeal to the counsel for the respondent within 2 days.
Yes, Lordship.
Have you filed a wakalat number? No.
Yes, Lordship, already filed.
Oh, fine. Within 2 days. Then list the matter. When?
Any day, Lordship.
List the matter. Give a date. Next week or after that, after 2 weeks.
13th of
My lord, you can have it
August.
next week.
No, the records will have to come also.
I understand.
13th of August.
Okay. That's all?
Item number 4.
Deeply
Most
obliged.
obliged, my lord.
Please, Your Lordship, I'm appearing on behalf of Samaria, Santip Samaria, who is out of station, my Lord. Interim order was granted at the initial stage of proceeding, my Lord. Interim order was granted at the initial stage. My Lord, I kindly request interim order may be continued.
No, just like that. Why is he not here? When is he coming?
My Lord, he has some difficulty today after...
He has some difficulty, let him come day after tomorrow.
My Lord,
What is this? We'll lift the stay order. What is wrong with this order? What is wrong with the order? Right. A genuine prayer has been made on behalf of Mr. S. Chamaria. While Mr. Tlang Thiang Thema appears as a legal aid counsel for the respondent. The present revision petition under Article 227 of the Constitution, read with Section 115 CPC, has put to challenge the validity of the impugned judgment and decree dated 12/8/25, passed by the Court of the Learned Civil Judge, Senior Division, Champhai, in civil suit number 13 of 2022, by which the appellant has been directed to pay rupees 13 lakhs to the respondent / plaintiff within a period of 3 months from the date of the order. Next paragraph. The issue pertains to the use of the what vehicle is this? This is a...
It's like a medium-sized truck.
Like a JCB? No, like a
Not
medium-sized.
JCB. Yes.
Use of a medium-sized truck and the use of the
It's a
respondent's medium-sized truck by the appellant. In respect of the construction progress being undertaken by the appellant. It was during the use of the said vehicle that a landslide had occurred which damaged the truck of the respondent.
partial damage.
Huh?
Partial damage.
Partial damage. Further, the landslide had also been partly caused by the blowing up of boulders or what? Had been right.
They have blasted rocks for construction of
what have I said? Further, the landslide had occurred partly because of the appellant blasting rocks for their construction project, for their project work. The learned trial court framed 4 issues which are as follows. Number 1, whether the suit was maintainable. Number 2, whether the suit was barred by law. Whether the suit is maintainable. Number 2, whether the suit is barred by law. Number 3, whether damage caused to the vehicle of the plaintiff is due to negligence of the defendants or an act of God. Number 4 is whether the plaintiff is entitled to the relief claimed, if so, to what extent. The learned trial court decided the first issue by holding that the suit was maintainable. And it also held that the suit had been filed within the period of limitation. The learned trial court also did the next para. The learned trial court decided the second issue by holding that the suit was not barred by law. Next para. The third issue was decided by the learned trial court by holding that the landslide cannot be considered to be entirely unforeseeable or extraordinary, given the nature of work carried out by the defendants. And although the natural force may have played a role, the defendant's negligence contributed significantly to the landslide. The learned trial court thus held that the landslide did not come within the threshold of, inverted commas, an act of God due to its preventable nature. As such, issue number 3 was also decided in favor of the respondent plaintiff. With regard to issue number 4, the learned trial court held that the defendant plaintiff was entitled to compensation amounting to rupees 25,63,170 with pendentalized interest at the rate of 9% per annum from the date of filing of the plaint.
If I may, my lords, I was awarded 13 lakhs out of the claim amount, my lords. Page 59.
No, you say was awarded
13 lakhs with interest.
13 lakhs. Okay, with interest at the rate of 9% per annum, if the same was not paid within a period of 3 months from the date of the impugned judgment and order. Okay. We'll list it on Thursday. Tell your counsel to pay. List the matter on Thursday, failing which the interim order may be vacated.
Slide my pledge.
Item number 5.
My lords, the issue is with respect of enhancement of the land valuation by the learned arbitrator. It has been enhanced without any evidence or to the facts how the revised valuation has been arrived at, my lords. Simply because there was a prayer before the learned arbitrator to enhance the rate, it has been arbitrarily enhanced and a rate has been fixed.
Yes. His cases, there is no evidence.
Yes, my lord. The reason we went to the arbitrator in the first place was that we were aggrieved with the categorization of land, which there is no sanction of law. The Kala has made broad categorization of land. He has divided the lands into Group A, Group B, and Group C. Your Lordship, there is no provision under the 2013 Act or the Highway Act allowing him or sanctioning him the power to categorize the land.
He categorized your land as
Group B.
Group B.
My lord, the Kala has already...
Did he categorize any land as Group A?
Yes, your Lordship. He has,
in the same award?
In the same award, he has made Group A, Group B, and Group C. And under each group, he has further subdivided each group under 3 categories. And the award has been made under Section 26 of the 2013 Act, which does not provide him any grounds, any power or any jurisdiction to make categorization of land. The reason the Kala says that he has made categorization of land is that there are no sale deeds apart from the town of Colosseum. So my land is in Gosen Bank and it's in Bilkotli Bank. And in section 26, Your Lordship, the law says that when there are no sale deeds to compare the land, the state government shall specify the floor price or minimum price, which the state government has not done. So by usurping, by assuming power himself, without any section of law, he has made categorization of land. That is why we went. And they said, that why are we put in group B? Why not group A? That was not answered, Your Lordship. So that was the main reason. And Your Lordship, as Your Lordship has aptly often remarked that when the law demands certain act to be done in a certain way, it has to be done in that way only, not in any other way. So that is one aspect, Your Lordship, which we agree. And number two, Your Lordship, is that the NHIDCL has to stand on its own leg. Before the arbitrator, Your Lordship, the NHIDCL, even though they were present in the hearing, they have not submitted anything, not a single word, not a single document. So our claim before the arbitrator was not objected at all.
And did they take this? Did they take this ground before in section 34?
No ground. This is the first time they have taken the ground.
Oh, and section 34, what was the ground of challenge?
The ground was that it is a violation of the Indian policy of law and so on.
That's what we are before Your Lordship again.
That is why, Your Lordship, if you see the order of the district judge, the ground for dismissal of the application was that it is the first time they have raised certain points, which they were there in the arbitrator. They just relied on the Prohibitions comment of the Kala. And the Prohibitions comment of the Kala simply says that we made broad categorization of land because there was no sale deed in those villages, which the law doesn't give him the power to do so. The law says that when there are no sale deeds to be taken example of, the state government has to make a notification. But the state government has not made any notification simply.
No. So Kala had put your land as Group B.
Group B.
So you challenge that.
We
saying
challenge
that
that
it should be Group A.
We should also be, why Group B? Why not Group A?
No, so but why should it be Group A? What was the
Since my lord, Gosen Bank is within Kolasip town itself.
Huh?
It's just near Rengtekon.
Your land is within Kolasip.
It's Kolasip town area, while others are given Group A, Group A1 are being given Group B.
So what is wrong?
My Lords, may refer to page 108 so that my Lords can understand how the categorization was done, my Lords. Page 108. And my Lords, the respondent fall in the category of grade A as well as in grade B also.
Huh?
Some of the respondent fall in category of grade A and some respondent fall in the category of grade B also. It is wrong to say that all of them fall under category B. So my Lords, this was a reason why grade A, B and C was categorized so that the Kolasip district headquarter can be kept under grade A, then grade B towns were kept and grade C other villages were kept.
No, let me see location. Gosen Veng. You are which Veng?
Some of the petitions are in Gosen Veng, but Your Lordship will see grade A has been further divided into 3, Roman 1, Roman 2, Roman 3. So Gosen Veng was further divided into 3, even though it's a small area, Gosen Veng was further divided into 3 groups. So each town, Boklang, Rengtekon, each area was further subdivided into 3 groups, and they were given lesser. One will have 133 per square feet, 106. So within the same locality, 3 compensations were given, which is not on the basis of any law, Your Lordship.
Anyway, we'll take it up some other day. I've got slight backache today. In my fourth match, fourth game, I don't know, I suddenly got a back pain.
My Lords, there is IA pressing for stay of operation of arbitral award. My Lords, the only reason is enhancement is without any logic, my Lords.
Friday. This is a matter of Friday. Next. Item number 6. Yes.
My lords, in this matter, the section 34 petition was dismissed on the ground of limitation. And my lords, the section 34 subclause 3 states that the date for limitation starts from the date the award is received. Whereas, my lord, under section 34, the
Give me
date...
the Arbitration Act. So the date of award is what?
My lords, the date of award is 17/10/2024 and it has been received on 23/10/2024.
And filed? Section 34 filed when?
21st January 2025. That's section 34, subclause 3 minutes. May I read for Lordship? An application for setting aside may be made after 3 months have elapsed from the date on which the party making the application had received the arbitral award. Or if a request has been made under section 33 from the date on which that request has been disposed of by the arbitral tribunal. My lord, section 33 talks about any corrigendum in the arbitral award. So there has been a corrigendum also, my lords, with this award, and it has been issued on 6th December 2024. So, my lords, whether corrigendum taken into consideration or not,
So
we have
30
filed the
days,
petition and within 3 months.
Where do you say that the limitation will start? From which period?
My lords, subclause 3, it says the limitation starts have elapsed from the date on which party making the application has received the arbitral award. From the date of receiving of arbitral award. 3 months have elapsed from the date party making that application has received the arbitral award.
Yes.
My lord, before anything else, I have filed IA application 148
For what?
for total recall of their ex parte order dated 3/6/2006.
Total, whose ex parte order? Ex parte order
On
by
the,
whom?
on the 3rd June, the appellants secured an ex parte order without hearing me. They filed a petition, an appeal petition on the 21st of...
Okay.
Well, that's for the notice only
Then,
issue.
I mean, this is an appeal filed by them, this notice issued on that day.
That's
What
it.
is this?
There's no ex parte order.
That's not, that is the normal thing, Mr. Counsel. Whenever a case comes for the first time in court, notice is issued. It is an ex parte order because usually the other side is not there in the first day.
No, my lord, they have filed appeal on 21st of May, and I should be given a copy.
No, you should not be given. You will be given only after court issues notice, because sometimes court dismisses the appeal. Instead of issuing notice, it sometimes dismisses the appeal on the first day.
My lord, I request my lord to be kind enough to direct the registry to list this IA and let the hearing be done tomorrow.
Okay. We can do it, no problem. Where is the mention memo? What is your IA number?
148.
148 of 2026.
Yes, I filed it yesterday on Friday.
Oh, मैं पहले हुआ वैसे नंबर खास सही दिखे चेक कर लो. This is a simple matter, right? Heard Mr.
Karthik Jain.
Karthik Jain, learned counsel for the appellant. And Mr. Joseph Mansang, counsel for the respondent number 1. The appellant has put to challenge the impugned judgment and order dated 8/4/2026 passed by the Court of the Additional District Judge Champai in arbitration petition number 2 of 2025, by which the appellant's application under section 34 of the Arbitration and Conciliation Act 1996 has been dismissed on the ground that the application under section 34 had not been filed within the limitation period of 90 days. Full stop. The counsel for the appellant submits that the arbitral award had been passed by the learned arbitrator on 17/10/2024, and the same had been received by the appellant on 23/10/2024. The appeal under section 34 of the Act was subsequently filed on 21/1/2025, that is within 88 days of receiving the arbitral award. He thus submits that in terms of section 34(3) of the Act, the limitation period of 90 days for filing an application under section 34 of the Act has not been violated. Full stop. Section 34(3) of the arbitral of the Act provides as follows. How do you prove that how do we know that you got it on 23/10?
My lords, may please refer to page 41, annexure 3. That's the peon book of the learned arbitrator.
43.
Page 41, annexure 3.
Yes.
My lords, second entry, below the signature, date is 23/10/2024, receipt of the award.
Okay.
By NHIDCL.
Let me see, is this the arbitral award number? Okay. The learned counsel for the appellant has also taken this court to annexure 3 of the appeal, which is the peon book, showing that arbitral award NH-06/KZL. Is it KZL?
Yes, my lords.
KZL/38/ARB-24 had been received by the NHIDCL Tui Khuatlang on 23/10/24.
My lords, this...
No, before that, I just want to see the award. How do I check the award? It will be in the arbitral, in the...
Award number, my lords?
Yes, the award number.
My lords, for that, we have to refer the next annexure, annexure 5 at page 43.
Okay.
My lords, the entry is for arbitral award number 38, but later on in 6th December 2024, the award number has been amended to 37.
This is 24, and this is pertaining, this is for the case number.
There has been a corrigendum.
Okay, right. The learned counsel for the appellant has also taken this court to corrigendum number NH-06/KZL/37/ARB-2024 dated 6/12/2024, which shows that arbitration No, which shows that arbitration case number NH-06/KZL/37/38, not 37, 38 /ARB-2024 is to be read as NH-06/KZL/37/ARB-2024. Correct?
Yes, my lords.
What's up? The above shows that, on going through the same, on going through the documents in the appeal, it is quite clear that the arbitral award executed on 17/10/2024 had been received by the appellant on 23/10/2024. As the Section 34 application had been filed on 21/1/2025. The same had been filed within 90 days from the date of receipt of the award by the appellant. Full stop. As such, it is quite apparent that the application under section 34 of the Act had been made within time. Where is this 21/1/2025? How do we prove that? That you had filed this 34
My
on
lords,
21.
may refer to page 5.
Page 5.
That's the impugned judgment. At the bottom, issue number 1.
Okay, or 521. Okay. Full stop. Full stop. However, on the prayer of Mr. Joseph Monsang, Lankasa for the respondent, list the matter tomorrow. List the matter tomorrow, along with IA number
148.
IA civil number 148 of 2026.
Yes, Lordship.
Tomorrow.
Yes, Lordship.
Placements.
Item number 7.
Or Mr. Monsang, we can do it at 2 o'clock also. We can call for the file at 2. Why wait for tomorrow?
Since it is in the registry, I mean...
No, we'll tell them by 2 o'clock lunch. By lunchtime they'll bring it here.
Fine with me.
Okay, 2 o'clock. Bring it 2 o'clock.
Thank you, Lordship.
So don't have to write that last part.
Thank you,
We
Lordship.
have it listed.
Your Worship, I was supposed to file my reply. Your Worship, I'm sorry I couldn't file it, so I won't be filing it, Your Worship.
Yes. Who's the other side?
It may come up next week. Then.
Now what is to be done here?
Your Worship, it may come up after a week. Admission.
Okay, Mr. Yarmalota submits that he will not be filing any affidavit.
In reply.
In reply. Accordingly, list this matter in the next week.
Item number 8.
Yes, may it please your Lordship. I am here for the petitioner, Lordship, and kindly allowed us to file our rejoinder against the affidavit in opposition filed by the respondent.
Madam, what is this case about?
Lordship, in this case,
You are claiming what? You are claiming damages?
No, Lordship. The respondent number 2, 3, and 9 illegally dumped soil to my land, Lordship.
Then you
to the
go
end.
file a civil suit. You file a civil suit. They dumped soil. That is damages. You have got to quantify what has been damaged. You've got to prove that damage has been caused. This is a writ petition. And another thing, madam, when you look, you see the stand of the respondents is that they have already been given 26,82,000 for acquisition of your land. When your land has already been acquired, where is the question of payment of compensation for damages?
But Lordship, the place where they dumped the soil is the unacquired portion of land, Lordship.
The unacquired portion. Okay.
Yes.
Okay, so they have acquired part of your land.
Part of the land and...
But they have not acquired your...
Yes.
So, you see, you go to the civil court and you ask for a verification to be done. Because you have got to prove that now out here, what has been damaged, we don't know. Now, how much money are you claiming out here? Okay. Yes, madam, who is for the NHIDCL?
Your Lordship, I'm appearing on behalf of my senior, Mr. Samuel Vanashata.
Where is he?
Your Lordship, he has personal difficulty.
Personal difficulty for what? What personal difficulty?
Medical reasons.
Medical reasons.
He is on leave.
Till?
Your Lordship, his mother is undergoing the operation.
Okay, no, it's a simple thing. You see, the thing, they are basically saying that you all are dumping soil. Well, you've got to stop dumping soil, number one.
Yes.
Number two is, why can't a verification be done? Verification be done to see whether soil is being dumped on the unacquired portion of her land. Yes, madam?
Yes, Your Lordship.
Who's for the government?
I am appearing for the state respondents.
Yes, so we constitute a survey to be done in the presence of NHIDCL and the petitioner and see if there has been soil dumping. If it is being dumped, then either you clear the dumped soil or you pay damages as may be decided by the authorities. Otherwise, madam, you have to go to civil court after that. This is because these are all questions of facts. You see? Because now they are denying, their affidavits, you see.
Verification.
And they are saying that this dumping of the soil has been done by the contractor.
Yes, the contractor.
Contractor is a party here.
Yes, Lordship, and the contractor are represented by Mr. Lalshat Rengathangte, but Lordship is not present here today.
Lalshat Rengathangte?
Yes.
The AG?
No. Politician.
Who is this Lalshat?
Lalshat Rengathang, brother of Mr. Laramzawa, senior counsel. Senior advocate.
That famous fellow. Okay. He is representing who?
The contractor, respondent number 9.
If he is not here, then what to do? We cannot do it. We'll dispose of this case. We'll direct the authorities to have a survey done, a verification. Because that is what you want.
Yes, that the respondents not to dump soil within the land.
We'll tell them not to dump. Not only that, but then we have got to identify the unacquired portion and then let them see if it has been dumped. If it has been dumped, we'll tell them to take it out. Both NHIDCL and the contractor will tell them to take it out. And damages, if any, should be worked out by the authorities. By whom? No, that for damages, I think. Is Revenue Department a party here?
No, Lordship.
Oh.
Yes, Your Lordship, we are made a party.
Huh?
And in fact, we have already filed our affidavit. Yes, respondent number 4.
The Revenue Department is a party.
Yes, Lordship.
And what have you stated, madam?
We have stated that in pursuant to the joint verification report received from the Divisional Forest Officer, the Office of the Deputy Commissioner requested the General Manager NHIDCL PMU selling to immediately stop the dumping of soil on the petitioner's land. The state respondents bears no liability towards the petitioner.
Okay. One thing is this, we'll have to, there has to be a verification made as to whether soil has really been dumped on the unacquired portion.
Yes, Lordship.
If it has been dumped, then we'll ask them to take it out. And otherwise, if they don't take it out, they've got to pay damages.
Yes, Lordship.
Okay, right. Heard? Miss
Rosie Manlom Sangi.
Rosie Manlom Sangi. Manlom Sangi.
Yes, Lordship.
Learned counsel for the petitioner. Also heard Ms. Zairem Sampui CGC appearing for the respondents number 1. Also heard Ms.
Zodin Pui Chakchwak on behalf
Zodhan Pui Chakchwak.
Zodin Pui Chakchwak.
Zodin Pui Chakchwak appearing for
on behalf of
Mr. Samuel Valatia the Changte. Correct?
Yes, Your Lordship.
Learned counsel for the NHIDCL. Also heard, that's all. Appearing for respondent number 2 and 3. 2 and 3, no? 2 and 3. 2 and 3.
Lordship.
Then also heard Ms. Caroline K. Lung Oipui appearing for the respondents number 4, 5 and 6. 4 to 8. The counsel for the respondent number 9 is absent. Full stop. Right. The petitioner's counsel submits that the petitioner is the owner of land covered by
Periodic Pata number.
Covered by periodic Pata number 105401/10/180 of 2003. So part of this land was acquired.
And part of the land.
She submits that while part of the land covered by the above said periodic Pata had been acquired by the NHIDCL
yes,
for construction of a road,
construction of NH6,
and compensation paid for the same, the NHIDCL and the contractor who is doing the road contract has been dumping earth on the unacquired portion of the petitioner's land. The petitioner's counsel submits that the NHIDCL and the contractor (respondent number 9) should be directed to remove all the illegally dumped earth from the petitioner's unacquired portion of the land and to restore the land of the petitioner to its original form / condition. Full stop. She alternatively submits that if the dumped earth is not removed, the respondent should be directed to make an assessment of the damages caused to the petitioner's land and pay the said amount to the petitioner. Full stop. Yes, madam, what you wanted to say something?
Your Lordship, in page 28, there was an NHIDCL, we have signed an indemnity bond in clause 25(1).
With the contractor?
Yes, Your Lordship.
That is between you and the contractor. We do not know. Full stop. That is her submission. She can ask for anything. Ms. Zaira Sangpuri, CGC, submits that she has got no comments to make.
Because the NHIDCL are working on behalf of Ministry.
So have you got, are you going to say anything? Huh?
Receive any instruction in this?
Submits that she has got no comments to make, as she has not received any instructions in this matter. Ms. Learned Counsel for the respondent number 2 and 3 submits that the dumping of soil/earth on the petitioner's unacquired portion of the land, if found to be true, would only result in the liability of the respondent number 9, in as much as the respondent number 9 would in as much as the NHIDCL is indemnified from any action taken by the respondent number 9, as per the agreement made between the NHIDCL and the respondent number 9. Next paragraph. Ms. Caroline K. Lung Oipui, the learned counsel for the state government, submits that in pursuant to a joint verification report received from the Divisional Forest Officer, Aizawl Forest Division, the Office of the Deputy Commissioner requested the respondent number 3 to immediately stop the dumping of soil on the petitioner's land. And as such, the state government has got no liability towards the petitioner in this regard. Full stop. I have heard the learned counsels for the parties. As can be seen from the affidavit filed by the state government, the DFO Aizawl Forest Division had written a letter to the Deputy Commissioner Aizawl with regard to the joint verification undertaken by the joint verification team, which showed that there was reckless disposal of earth from the road construction activity undertaken by the NHIDCL through its contractors. Accordingly, the report made by the verification team also stated that there were dumping of earth spoil in various locations, and the concerned authority may be required to issue stay orders for dumping, barring dumping of earth spoil. Full stop. Thereafter, the additional deputy commissioner and Kala CL NH-06 issued a letter dated 2/1/23 to the respondent number 3, informing him that soil dumping should be done only on designated spoil banks and dumping grounds, other than dumping on private lands. Full stop. The next para. The fact that the petitioner is here clearly shows that
Your Lordship,
he has some grievance.
it should be letter dated 9/1/2023.
9/1/23.
Please, Your Lordship.
The last one will be 9/1, 9/1. Not 2/1, 9/1. The fact that the petitioner is before this court clearly shows that there is all possibility that dumping of earth spoil is going on the unacquired land of the petitioner. As such, this
Your Lordship, based on that, in page 5, para 6, the NHIDCL, the general manager, as well as the team leader, has visited the site, and they found that in Annexure 2, page 18, they found that it belongs in the acquired ROW.
So we'll have another verification made. As such, this court is of the view that fresh verification should be conducted. Where is this place?
Thingsol, Claisol District, Lordship.
Should be conducted by a team consisting of a surveyor of the Land Revenue and Settlement Department, the NHIDCL, representative of the respondent number 9 and the petitioner, to verify whether earth spoils have been dumped by the respondent number 9 on the unacquired portion of the land of the petitioner covered by periodic pata number so.
And Kala should also be included?
No. Why? No need. Why should Kala be included? You said unacquired portion. Okay. The depending upon the report made by the verification team, the NHIDCL and the concerned contractor should have to act upon the said report. In case of the dumped soil not being cleared by the above authorities, by the above respondents, the petitioner may make a claim for damages before the learned civil court. The entire verification, spot verification on the land of the petitioner should be done within a period of 1 month.
Okay. Yes, Lordship.
The writ petition is accordingly disposed of. Oh.
Obliged, my Lord.
Item number 9.
देखो मेरा फाइल है ना किताब वो बड़ा वाला वो मोटा वाला नया वाला दो है नया वाला
May it please your Lordship.
Item?
Item number 9, Lordship.
Yes.
Lordship, this writ petition concerns an unauthorized excavation in the petitioner's land, Lordship, by the state authorities. Now, Lordship, in this, no notice was given to the petitioner, Lordship. No information was given to him whatsoever, Lordship. Now, Lordship, what happened was the petitioner was hospitalized, Lordship, in the month of
No, so you have got a land,
Yes.
you have got land covered by LSE.
Yes, Lordship.
And they encroached upon your land.
They encroached upon
And
our
did
land,
what?
Lordship. And then, Lordship, what the purpose of this was that a project was the project was that to build a retaining wall, Lordship, on the road. Now, what happened was that around 18 meters, Lordship, of our land has been excavated, Lordship. No information was given to us, and the soil and the debris were dumped on our land, Lordship. Now, Lordship, in this, Lordship, we do not oppose the project, Lordship. We are okay, we agree with it. But, Lordship, the very fact that our land had been encroached without any information to us, now that is the main concern, the main reason for filing this repetition, Lordship.
Yes, Your Lordship. This matter, in the first time when it was listed, Ms. Lal Nui was appearing, and however the court directed her to take instruction. And on the next court date, Your Lordship, I appeared and I have given my instruction, the instruction which I have received, but it was not highlighted in the court order. And Your Lordship, as per the instruction which I have received, actually now the claim which the petitioner had made in the present writ petition is already solved. And now the petition is actually infructuous.
So, however, Lordship, it was not solved, Lordship. What happened was that he was never called by any sort of notice, Lordship. However, he was just called just to have a joint inspection, Lordship. There is no any order as well. Now, Lordship.
No. You see, Mr. Counsel, what do you want?
Lordship, what we do want is that let the respondent take action as per accordance with law, Lordship. However, in this, Lordship, the excavated property, the excavated land, Lordship, what they have done is they have dumped the soil and the debris in our properties as well, Lordship. And around 18 meters of our land has been encroached, Lordship. If they want the land...
So what do you want? What do you want? You want money? You want them to go out from your land?
Lordship,
you want to clear the earth spoils? What do you want?
So, Lordship, what we do want is that if the respondent authorities require the land, Lordship, let them acquire it as per law. And the second thing is the Lordship, if all the soil and the debris...
Mr. Counsel, have you submitted a representation to them?
Yes, Lordship, we have submitted.
And they have not replied?
They have not replied, Lordship.
And she's saying it's infructuous?
Lordship, there is no
No,
any...
Your Lordship, the initial situation is that...
You see, your prayer.
Yes.
Your prayer is, issue a writ in the nature of mandamus, directing the respondent so to desist from carrying out any further excavation, construction or activity on the petitioner's land.
Yes,
now, have you all finished your work or you are still continuing?
No, actually, Your Lordship, after seeing his representation, a committee was constructed, and the petitioner was instructed to appear on the spot verification. But however, he did not appear. But pursuant to that one, they are having a communication through phone, and the petitioner was instructing the department that they can construct the retaining wall, and whatever step they have taken, that has to be informed to him. So that was done, Your Lordship, and now the construction is going on.
So now, Lordship, with regards to the spot verification, Lordship, on the day of the spot verification, he was in fact present, Lordship. And I have some pictures, Your Lordship, if I may.
No, Mr. Counsel, forget pictures.
This
the issue is, what do you want? What do you want from them?
So, Lordship, if the respondent authority requires the property which they have excavated, Lordship, for the purpose of the retaining wall, let them acquire it as per law, Lordship. That is the first thing.
But where is the...
It is not written in the writ petition.
Where is your prayer for that?
This prayer.
Now, Lordship, what we actually require now, other than that, is the Lordship, to bring the petitioner's land in its original form, Lordship. Whatever soil has been dumped, Lordship, let it be cleared up, Lordship.
Actually, Your Lordship, the place is that Falkland Road, that is the sinking area. And in order to prevent that sinking place, retaining wall was constructed. And at the time of construction, it is not in the knowledge of the respondent that the petitioner had acquired the land. And regarding the representation submitted by the petitioner, the respondent.
Look, madam, why don't you file an affidavit?
Yes, Your Lordship, I will be filing.
No, when?
No, I will be filing.
When? You will be filing till kingdom come, we cannot wait.
No, Your Lordship, this is the third time it is listed.
No, sorry. This is
So
not
I
the
have
first time. This was listed in April also. Counsel for the petitioner, who submits that the petitioner is the owner of land covered by LSC number 3341 of 1985. However, the respondents have, without the permission of the petitioner, encroached upon his land and started excavation of his land and also started erecting a retaining wall without retaining wall. Full stop. The petitioner's counsel submits that if the respondents want to acquire his land, they should acquire it as per law. Full stop. Ms. Vanesiami, the learned GA, submits that she will be filing affidavit within
3 weeks, Your Lordship.
within 3 weeks. Full stop. On perusing the records, it is seen that despite the alleged encroachment made by the state government on the land of the petitioner, the respondents are taking their own sweet time for filing an affidavit. Full stop. The prayer of the GA for filing affidavit is allowed. Affidavit deposition is allowed. However, till the time the state government filed their affidavit, the state respondents are restrained from doing any kind of work on the land of the petitioner covered by LSC number so.
Your Lordship, in that regard, the excavation work.
No, everything will be stopped. You don't want to file affidavit, everything is stopped. You file it, if you want, we'll take it up tomorrow. You call your officers, all your engineer-in-chief, everyone, let them come, tell, you file an affidavit, madam, how, you want to do work, but you're not, you're encroaching his land. You'll not be allowed. If you want you to obtain instructions, we'll take it up tomorrow. You take it up tomorrow, madam, you call your officers, we'll take it up.
Yes, Your Lordship.
When? Tomorrow?
Tomorrow.
List the matter tomorrow. Just say, you put everything there, I'll modify it. This is the matter tomorrow.
Much obliged.
Item number 10.
My Lord, in this matter, I am recently engaged by respondent 1 and 2, State Election Commission.
Is it infractious?
Yeah, that's why I want to submit.
It's infractious, correct?
It has been result already declared everything. It's become infractious. They challenge their appointment.
Yes, madam.
May it please Your Lordship, the petitioner respectfully pray for leave of this court to permit amendment of the writ petition.
Why amendment, madam? What is this?
Because the amendments are necessary for this writ petition, since the writ petition was filed for the purpose of the last election, Aizawl Municipal Corporation 2026, which
madam,
was...
you file a fresh petition, the life of this petition has died. The election was to be held on April 15th. No, I will submit. Wait, where is that?
21st election was...
21st,
My Lord, however...
polling was to be held on 21st April 26, and then it has finished, so what remains?
My Lord, it's for the coming subsequent election.
Coming subsequent election, you file afresh. That is a new subject matter.
But my Lord, we are praying for amendment because
To avoid multiplicity of writ petition.
You tell your senior. Who is the senior?
Mr. Ramzal.
Tell him that court is not inclined to allow filing of amendment. Your prayer is with regard to the April 26th election to be held. That is finished. What remains? You file a fresh one.
My lord, their main challenge is appointment orders. Appointment orders.
Let us see those appointment orders. I know those appointment orders, 2/4/2006.
Yes, it became infructuous because they conducted their role everything.
As per in accordance with the for general election to Aizawl Municipal Corporation 2026. You have been appointed for the AMC election. AMC election is finished.
Yes,
what amendment do you want?
See, for coming election, like I said, for subsequent election, in our prayer also we have said that to make this rule absolute and...
Madam, you are...
No, fresh appointment will be suing. Fresh appointment they can challenge. Subsequent election, only fresh appointment, they'll perform their duty.
Just a minute. This 11th April 26 is finished. That it's died a natural death. Let me see. 2/4/26. Where is this 2/4/26, madam? Which page is it? 2/4/26. 25 to 43. 25 to 43.
Appointment orders.
Page number 26.
31. Starting from 28. Starting from 28, my lord. They were appointed on different dates. Appointment were done on different dates.
Madam, they are all appointed for the AMC election of 2026.
Yes, my lord.
That election has finished. Now, what amendment do you want?
Yes, my lord, for the coming election, like I said.
Coming election when? Which year?
2028 and...
2028, but this appointment is only for the 26th election. It says here for AMC 2026. For 28, there is nothing to challenge.
See, my lord, we want to avoid, like I said, multiplicity of proceedings that do not prejudice.
Madam, for a lawyer, it's very good to have multiplicity of proceedings. You'll get, if you have one, look, I'll just tell you like this. Will it be better for a lawyer if you get one case or you get 10 cases?
But I'm thinking of the petitioners' welfare.
Huh?
I'm thinking of the petitioners' welfare. Petitioners.
Madam, all these persons will be gone by then. How you don't know? They might have retired. They might go off. We don't know. And for appointment for the AMC election of 31 or 30 or whatever, I don't know what is the period. You're going to have a fresh appointment order. This appointment order is only for AMC election 2026, which has already finished in April. You tell your senior, sir, what have you sent me to argue? Ask him. I'm just looking, I'm just seeing, all of them are saying AMC 2026. AMC 2026. AMC 2026 is finished. Heard Miss
Zothan Sangi Mark.
Zothan Zami
Sangi.
Zothan Sangi Mark. This.
Hello, Jesse Lansang, I'm for respondent.
Heard Mr. Jesse Lansang, I'll consider for the respondent.
1 and 2.
Respondent number 1 and 2. The petitioners herein are all working as assistant professors in Pachunga University College. And they have been appointed as team leader of home voting team or as a presiding officer for the upcoming election to the Aizawl Municipal Corporation (AMC) 2026, which according to them is not commensurate to their rank and status. They contend that instead of being appointed as team leader or as a presiding officer, they should have been appointed as micro observer, additional micro observer or master trainers, etc. It has been stated at the bar that in the meantime, elections to the Aizawl Municipal Corporation 2026 has concluded
On 27 April.
on 27th April 2026. On perusing the appointment orders issued to the petitioner, it is seen that they have all been appointed in relation to the general elections to the AMC, general elections to the AMC 2026. As the said elections have concluded, there is nothing remaining in the present petition. The writ petition is accordingly dismissed as infructuous.
Much obliged.
For those, item 11.
May it please your Lordship, this is an application for condoning the delay of 667 days in filing the connected RSA number 6 of 2025. The reasons for the delay has been explained in paragraph number 2, my Lord. Paragraph number 2A, page 3, my Lord.
Yes?
Yes. That the applicant had come to learn of the impugned judgment and order dated 24/7/2020.
Were you part of did you participate in this RFA?
Yes, my Lord. I am the appellant in the RFA, my Lord.
Then?
And, my Lord, the RFA was dismissed. I challenged the ex parte heirship certificate issued to the daughter-in-law of my grandfather. And
ex parte
heirship certificate issued to the respondent.
And still your appeal was dismissed?
Appeal was dismissed. I thought I was, at the hearing, the court decided I won, but however, when the order came out, the case was dismissed, unfortunately.
Then?
Then, after the RFA was dismissed, I instructed my previous counsel to file the appeal. However, he had not filed the appeal, and I came to learn only after the respondent herein claimed another landed property at Tanshil, and we had some quarrel. And
what Tanshil? What?
There was other landed properties Tanshil.
There was what related?
Other landed properties.
Okay, at Tanshil.
Tanshil, yes, my Lord. So she had claimed some other landed properties, and during that time, she pointed out that she had already won the case, and I came to learn that no appeal has been filed. So I engaged a new lawyer. That was the reason for the number of days, my Lord.
That's a very vague.
Yes, it's a bit vague, my Lord, because...
You see, what the Supreme Court has said in one of the cases is that when you are going to lay the blame on the lawyer, the lawyer should be made a party also. Isn't that right, Mr. Karthik Jain? Have you heard her? He has not heard of it. He has not heard the judgment. There is it says here, so that because then because it can affect him also.
Yes, my Lord, there was some as I've mentioned, there was some miscommunication between them, my Lord.
Between whom?
Between the present appellant and his previous counsel. I've also inquired personally, and he said due to some material instructions, he had not pursued the case. And the present petitioner was of the opinion that he had done everything. So there was some miscommunication between them, my lord.
Well, what is the merits of the case?
Merits of the case is that, my lord, my grandfather had a landed property, and these landed properties were, after his death, the daughter-in-law had applied for heirship certificate before the first trial court, and she was granted heirship certificate. However, as per the Mizo Inheritance of Property Act, a daughter-in-law is not in the list of legal heirs, my lord. So she cannot inherit the property.
No, so your grandfather had how many sons, how many daughters?
My grandfather had 2 sons. I am the son of the eldest son, and the respondent is the wife of the youngest son. And
So there are 2 sons, the younger son.
Yes, and the youngest son also has children. So, if the children of
No, you're not making sense. You said your grandfather had 2 sons. Correct?
Yes, my lord.
You are the son of the elder son.
Yes, my lord.
And she is the
the wife of
the younger son.
Younger son.
Okay, and the younger son has got children also.
Children also.
Then,
instead of making her children apply, she had applied, and there is no provision for a daughter-in-law to inherit the property, my lord.
What happened to you? Your father had died by that time.
Father had died, my lord.
So the younger son was there.
Yes, my lord.
So the mother can, and under the customary law,
mother can.
She can occupy the main bed.
Yes, my lord, but it is my grandfather's property, not the property of my uncle. It is the property of my grandfather. So I am an interested party. And under the...
But you are the grandson, you don't have a right.
No, my lord, I would have a right, because as per your lordship judgment, inheritance flows automatically. And if my father died,
Your father died after grandfather died or what? Or before? Who died first?
Grandfather was expired. Grandfather was expired on 2014. His father expired on 2020. 2020. They already live separate household during the lifetime of the grandfather.
Okay.
His father did not make any claim.
Okay.
And we are the one who are living in the family main house.
With the main house.
And moreover, although I do not have the documents, the suit property, as on date, is now settled in the name of the youngest son of the present respondent.
That is, my lord, as he has pointed out, my father died before my grandfather. So, as per
Your father died after your grandfather. What are you doing? Your grandfather died in 2014.
Yes, my lord.
And your father died in 2020.
2020.
Then, who died earlier?
I apologize, my lord. So, my lord, nevertheless...
And your Indang.
No.
Your father was Indang in 2020.
My lord, since it's the property of my deceased grandfather,
Maybe, but then you're Indang. You're becoming greedy.
And my lord, this RSA, because I filed this RSA because it's a pure question of law, whether a daughter-in-law can inherit the property of the head of the family, my lord.
We are not on merits right now. We are on the. I just wanted to know to understand the perspective.
Yes, my lord.
We are now going to go purely on whether delay can be condoned. There is the latest judgment, I think, latest one, that you should not look at the merits of the case.
But my lord, I have one 2023 judgment saying that...
There is a 2025, I think last week. Or week after the...
Yes, my lord, there is a conflicting judgment.
Huh?
And 2025, the coordinate bench of this Honorable Court in 2026 has held that the delay can be condoned and the appeal has to be heard on merits as a grave miscarriage of justice may occasioned for not condoning the delay. This is the judgment of the coordinate bench on 12/6/2026. So, my lord, if this judgment is allowed to stand, then a daughter-in-law can inherit the property. It would mean amending the act itself, my lord. What is not allowed in the act.
No. You see, some things that don't go as per the statutory law can go as per the customary law. Customary law is also accepted as a law in terms of Article 371G.
But the heirship was given under the Mizo Act, my lord.
What Mizo Act? How can heirship be given under
the heirship was given under the Mizo Marriage, Divorce and Inheritance of Property Act. So
show me the provision under which heirship certificate can be given under that act that they're talking about.
If I can take your lordship to the page 16 of the main appeal, my lord. Section 30 of the, it was issued under the Section 30 of the Mizo Marriage, Divorce and Inheritance of Property Act, Section 30. And Section 30, as per Section 30, page 16 of the memo of appeal, my lord. Heirship certificate application number 1320 of 2016 under Section 30 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014. And it is written, whereas on the date of your father died on 24/2014, you applied for heirship certificate under the Mizo Marriage, Divorce and Inheritance of Property Act in respect of the following properties, namely landed property so-and-so, LSC number so-and-so. This certificate is accordingly granted to you, Vanal Somi, wife of R. Silal Monpui, a resident of Tanshil, Bengpui, Aizawl, Mizoram, and declare you as the legal heiress of the deceased J. Thang Nuna in respect of the above mentioned property. J. Thang Nuna is his father-in-law. It's not his father. It's not her father.
It's for the child, it's for the grandchildren.
Maybe, but technically it's wrong, my lord.
You see, maybe. But at the end of the day, you're also the grandchild.
I'm also the grandchild.
The children of that lady is also the grandchildren. And they're living in the main house.
They're living in the main house, but the heirship certificate was issued ex parte. I should be given a chance to defend the estate of my deceased grandfather, my lord. And as per section...
And what? And you've got your own property also, your father's property.
No, my lord. And as per section 31, my lord, there is no provision for a daughter-in-law to inherit the property. If the grandchildren file, then it's one aspect, but they have not done so.
But come down to this. Show me, why should we condone 667 days?
I'll read out my grounds, my lord. Paragraph number 2A, that the applicant had come to learn that the impugned judgment order dated 24/7/2023 has been pronounced by RFA number 11 of 2020, filed by him, has been rejected. The applicant then requested his previous counsel to file the second appeal against the impugned judgment and order dated 24/7/2023 on 20/10/2023. Thereafter, the applicant was under the impression that necessary steps have been taken for filing the second appeal by his previous counsel. B, that however there was some miscommunication between his previous counsel and the applicant, and his previous counsel had not taken necessary steps for filing a second appeal, and this was found out by the applicant only on 15/5/2025.
Then what did you do? You just waited for your counsel for 667 days.
Yes, when the respondent had also claimed other landed properties located at Tantril, Aizol.
You didn't ask him what happened to the appeal. For more than a year, you just went around having momos and tea somewhere in some.
My lord, he
dreaming about that property.
He was at Khozol, my lord. He was out of station.
Khozol?
Yes, my lord.
So, for how long was he out of station?
And when he found this out, some landed properties located at Tantril were claimed by the respondents from the applicant's aunt. And during their argument, it has been pointed out that no appeal has been filed. And when the applicant gained knowledge of the inaction of his previous counsel, there is already a delay of 571 days.
You could find out about this from the other side. You could have easily called your lawyer and said.
Yes, my lord, to his knowledge, he had done everything, but unfortunately it has not been done.
Any citations in your favor?
My lord, I have placed one citation, that is 2023, volume 10, SCC 531, my lord. Paragraph number 35, my lord. We find that the High Court in the present case assigned the following reasons in support of its order. Paragraph number 35.1. The law of limitation was founded on public policy, and that some lapse on the part of a litigant by itself would not be sufficient to deny condonation of delay, as the same could cause miscarriage of justice. The expression sufficient cause is elastic enough for courts to do substantial justice. Further, when substantial justice and technical considerations are pitted against one another, the former would prevail. It is upon the courts to consider the sufficiency of cause shown for the delay, and the length of delay is not always decisive while exercising discretion in such matters if the delay is properly explained. Further, the merits of the claim were also to be considered when deciding such application for condonation of delay. Further, a distinction should be drawn between inordinate and explained delay and explained delay, where in the present case, the first respondent had sufficiently explained the delay on account of negligence on the part of the government functionaries and the government counsel on record before the reference court. The officer responsible for the negligence would be liable to suffer and not public interest through the state. The High Court felt inclined to take a pragmatic view, since the negligence therein did not border on callousness. Given these reasons, we do not consider discretion to have been exercised by the High Court in an arbitrary manner. And I have one more citation, which is the decision of the coordinate bench of this Honorable Court, IA number 14 of 2025. Paragraph number 9, my lord. In the case of State of Nagaland versus Lipok Au and others, reported in 2005, volume 3, SCC 752, the Apex Court has held that if refusal to condone the delay result in a grave miscarriage of justice, it would be a ground to condone the delay. Having regard to the aforesaid aspect...
But there's a recent judgment last week.
Yes, my lord. Having regard... Yes, my lord. Having regard to the aforesaid aspect of the matter, it is possible that unless the appeal is heard on merits, a grave miscarriage of justice may be occasioned. So what I'm praying for is that, my lord, in the RSA, we have challenged the inheritance made by a daughter-in-law, which is not permissible in law. And that question has to be answered, my lord, in my humble opinion. Because if this type of thing is allowed to go on, then what would be the purpose of the act, my lord? If an heirship certificate can be granted to a person who is not included in the list of heirs, what will be the purpose of the act?
What do you mean she cannot, she is not included?
My lord, section 31 clearly provides the list of heirs, my lord, of the Mizo Marriage Inheritance of Property Act. In the absence of a will, the following provision shall apply. There is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, and 12.
I think even daughter-in-law will be there.
Daughter-in-law is not there in any of those number 12, my lord. There are sons.
She could be holding it in trust of her kids.
But my lord, yes, that can be, but my lord, this is a code of law, my lord. The code of law cannot issue an heirship certificate under section 30 to a person not included in the list of the legal heirs, my lord. If it has been so issued to the children, then it is...
I'm not going on the merits.
Pardon, my lord?
I'm not going on the merits.
Yes, my lord, I know. But this is wrong, my lord. This judgment is wrong. The heirship certificate itself is wrong. So, my lord, this is a court of appeal. So, my lord, I humbly request your lordship to take up this matter so that all the wrongs committed by the trial court will be rectified, my lord.
I think if we leave it be, then the children, the grandchildren of the owner, they'll be very happy. They're living in the main house. Supposing you fight for it, you win, you're going to kick them out from their house while you already have a house of your own.
No, my lord, I don't have a house of my own, my lord.
There, your father's house is there.
My lord, my humble prayer is that let the delay be condoned so that the wrongs committed by the trial court, which is clearly evident, my lord, may be rectified. That is all.
Let us hear the other side. Yes.
May I please your lordship? My lord, in this case, newspaper publication was made by the trial court prior to issuance of the heirship certificate, and the children of the respondent's mother had also issued NOC in favor of their mother. And in this case, my lord, as your lordship had already, I have already addressed to this court that the suit properties are now settled in the name of the youngest son of the respondent. And the main reasons for dismissal of the appeal before the trial court was regarding the question of locus standi of the present appellant. Since his father had not made any challenge during his lifetime.
During his lifetime.
And plus, they were already indung. And
yes.
And moreover, my lord, I would like to place one authority rendered by this honorable court in the case of W. Rabi Singh versus State of Manipur, reported in 2012. 2012, volume 1. GLT 435. In this case also, my lord, they have blamed the negligence of the advocate, but the names of the advocates was not mentioned, and they were only taking this plea only to cover up their lectures on the part of the applicant. If I may take a lordship to para 6 onwards.
Yes.
I'll read from para 5. We have given our NCS thought to the submission of the learned counsel of the parties. We have also perused the contention made in para 3 to 11 of the instant application. On perusal of the contention as stated in the application, it appears that there are only some vague and omnibus allegations against the learned counsel engaged by the petitioner in his writ petition. From the application, it also appears that the appellant engaged more than one lawyer in the writ petition filed by him, and admittedly, he did not divulge the name of the lawyer, for whose fault he could not file the writ appeal in time. It appears from annexure that a no objection letter issued by one learned counsel, wherein he stated that he had no objection to conduct the writ petition being WPC number such and such, and any writ appeal with reference to the said writ petition by any other advocate other than him, meaning thereby the learned counsel had consented only to the engagement of other counsel in the writ petition. Therefore, according to us, it cannot be safely said that the delay caused in preferring the appeal was due to the negligence of the learned counsel. There is no doubt that a litigant should not be penalized either for the fault or for the wrong advice of his engaged lawyer. But in the instant case, though the applicant appellant was informed again and again by his counsel regarding non-filing of the appeal in time, then also he had pursued such lawyer and persistently gone on misunderstanding regarding the period of limitation. By this time, it is the settled position of law that every wrong advice, negligence of the counsel will not ipso facto amount to sufficient cause, entitling a party to claim indulgence under Section 5 of the Limitation Act. More so, when the alleged negligence is culpable in nature, then the same cannot be treated as sufficient cause for delay. We have no hesitation to say that by engaging a counsel, a party to the case is not fully relieved from his duties and obligations in the matter. Where a party either does not get proper response from his counsel or the counsel is willfully misleading him, then it is the party who is in default and negligent and shall have to bear the consequence. And where the litigant himself prima facie in default, the negligence of the counsel also cannot come to aid in a claim or application to establish sufficient cause for condonation of delay. We are of the further opinion that when the earlier engaged counsel of the appellant failed to prefer the appeal for a period of 3 months, even after his persuasion, then he ought to have engaged another counsel at that time itself. It further appears from the record that he waited for more than 2 years for preferring the appeal. He should not have depended on the assurance of his previous counsel. More so, admittedly, the applicant did not divulge the name of his lawyer for whose fault mistake he could not file the appeal in time. Thus, the learned State Counsel rightly contended that the applicant is not a rustic villager, rather a government employee who is very much presumed to be aware about the practice and procedures of the court, and it would not be proper to grant the relief sought for. There is no general principle saving the party from all mistakes of its counsel. If there is negligence, deliberate and gross inaction, or lack of bona fides on the part of the party or its counsel, there is no reason why the opposite sides should be exposed to a time-barred appeal. From reading the application of the applicant, it appears to us that the plea of negligence of the engaged counsel is taken only to cover up his own letters with an attempt to save the limitation. My Lord, in the present case also, they have not named the said lawyer who they have engaged earlier.
There is a Supreme Court decision, which says that they should be made parties. I read it some time back, and I had used it once also, 2-3 years back. Yes, any other?
And the case of Basawaras, my Lord, 2013 SEC, volume 14, page 81. Para 11, 12, 13, 14 and 15. Para 11 to 15. I may read para 13.
Yes.
The second paragraph. An unlimited limitation would lead to a sense of insecurity and uncertainty, and therefore limitation prevents disturbance or deprivation of what may have been acquired in equity and justice by long enjoyment, or what may have been lost by a party's own inaction, negligence, or laches. The law on the issue can be, para 15, summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In a case, if a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have not acted diligently or remained inactive, there cannot be justified ground to condone the delay. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within the perimeters laid down by this court in regard to the condonation of delay. In the present case, my Lord, they have not approached this court with clean hands, my Lord. As stated by them in the application, the main reasons behind filing this appeal is the dispute between the present respondent and his aunt in different case. That is the main reason for the purpose of filing this case.
Dispute between you and?
My sister-in-law. The grandfather has plenty of landed properties. He distributed to each and every one during his lifetime. And some of the share of the respondent's family and his children, they have mutated fraudulently without their knowledge. So we have initiated different case against those persons. And that is the statement, what can be seen from the statement given herein.
There is a judgment recently, like I said last week only, I think, this Supreme Court has said that shouldn't go into the merits of the case. When you're considering this.
In the present case, my lord, they failed to make
You'll
out.
have to find out.
Yes,
I'll
I'll
find
look
out.
into it.
There's probably Sandeep Mehta was there, I think. I'm not sure. Justice Mehta. Justice Sandeep Mehta might have been there. I'm not sure. I'm not sure who were the judges. Anything else?
In view of the submissions and the authority I relied upon, my lord, the applicant failed to make out a case and the application is liable to be dismissed.
Get me those judgments, get me that. I think you just have to do some.
Yes, I'll look into it.
Okay, right. Heard Mr. Zoram Chana, learned counsel for the applicant. Also heard Mr. Victor L. Rate, learned counsel for the respondent. This is an application for condoning the delay of 667 days in filing the appeal against the impugned judgment and order dated 24/7/23 passed by the District Judge Aizol in RFA number 11 of 2020. Achha, you say dismissing RFA number 11 of 2020. The applicant's counsel submits that the subject matter in issue is the land belonging to the applicant's grandfather. He submits that after the death of the applicant's grandfather, the wife of the youngest son of his grandfather, that is the respondent herein, had applied for heirship certificate in respect of the grandfather's land. The learned trial court had granted heirship certificate to the respondent. The same was put to challenge by the applicant herein, who is the son of the elder son of his grandfather. However, the challenge to the grant of heirship certificate made by the applicant via RFA number 11 of 2020 before the District Judge Aizol was dismissed by the impugned judgment and order. Next paragraph. The applicant's counsel submits that there is a delay of 667 days in filing the appeal against the impugned judgment and order dated 24/7/2023 due to a miscommunication between the applicant's counsel and the applicant. The applicant's counsel submits that the applicant had requested his previous counsel to file a second appeal against the impugned judgment and order. However, the same was not filed by his previous counsel, and it was only on 15/5/25 that the applicant came to learn that no appeal had been filed by his counsel. When the respondent had told the applicant about the same. That's all. That's their only ground.
Yes, Madam. It's in respect of tree. The heirship is in respect of tree landed properties, Madam.
I'm not on that. That is a different. That's on merits. First up.
And the other reasons for the delay is that he was posted at Kozol, and he was not, and he was unable to immediately pursue.
Further, as the applicant was posted at Kozol, which is a 3-hour drive from Aizol, that the applicant could not pursue with his previous counsel with regard to whether an appeal had been filed. It was only on 14/7/2025 that the applicant collected his brief from his previous counsel. Oh, not 15/7/25. And thereafter met his present counsel on 17/7/2025. Thereafter, the present appeal had been filed after 667 days. First up, the applicant's counsel submits that the delay in filing the present appeal has been due to the negligence and fault of the applicant's previous counsel who did not file an appeal. He also submits that the grant of an heirship certificate to the wife of the younger son of his grandfather was a grave injustice, and it was a grave miscarriage of justice, and due to which the delay should be condoned. In this regard, he has relied upon the decision of the Supreme Court in the case of State of Nagaland versus Lipok Ao and others, 2005 3 SCC 752. In support of his submission that the delay should be condoned, he has also relied upon the decision of the Supreme Court in the case of Shio Raj Singh, deceased through so and so, 2023 10 SCC 531. Next para. Mr. Victor L. Rate, the learned counsel for the respondent, on the other hand, submits that the grandfather of the applicant and the father-in-law, who was also the father-in-law of the respondent, had expired in the year 2014. The heirship certificate had been granted to the respondent on when?
1st November 2016.
On 1/11/2016. The father of the applicant, who was the brother-in-law of the informant, did not make any challenge to the grant of heirship to the respondent. Further, the father of the applicant had left the ancestral home and set up a new household and set up a separate household in another locality. It was only after the death of the applicant's father in the year 2020 that the applicant has now claimed has claimed the property that had devolved upon the respondent by filing an appeal against the heirship certificate. In RFA 11, in the year 2020. The learned counsel for the respondent submits that in terms of the judgment of the Supreme Court in the case of state of Depok also, the Supreme Court has held that refusal to condone delay, held that if refusal to condone the delay results in a grave miscarriage of justice, it would be a ground to condone the delay. In the case of Shivraj Singh Supra, Shivraj Singh is by you, na? No, in the case of, he has also relied upon the decision of the Supreme Court in the case of 2013-14 SEC 81. Para?
11, 12, 13,
Para
15.
Now, where it has been stated that sufficient cause should be given a liberal meaning to ensure that substantial justice is done, but no, don't say but. Only so long as negligence, inaction or lack of bona fides cannot be imputed to the party concerned. He has also relied upon the decision of the Supreme Court in the case of decision of the division bench of this court in W. Rabi Singh versus State of Manipur and others 2012 1 GLT 345. Wherein para?
Para 6.
It has been held that it is settled position of law that every wrong advice / negligence of the counsel will not ipso facto amount to sufficient cause entitling a party to claim indulgence under Section 5 of the Limitation Act, more so, when the alleged negligence is culpable in nature, and then the same, no, that is not, then the same cannot be treated as sufficient cause for the delay. So, you are going to give me the decisions or what?
I am still searching, my lord. The bench is Justice P.V. Pardiwala and R. Mahadevan.
Okay.
The network is very slow right now. Network is very slow.
Okay,
I
you
cannot
give me
get the full
later.
text yet. Yes, Your Lordship.
We will decide. When can you give me? Okay, we just say list this matter day after tomorrow. No, say list this matter on Friday. In the meantime, we'll do it. Because your judgments have to be given to me in the meantime.
That's obliged.
Obliged, madam.
Item number 12.
My lord, paper book, we have received the paper book, so if this matter may be listed for hearing in due course.
Who's for the other side?
Miss Lalnunhui.
Okay, right. Miss Lalroth Feli, Learned Counsel for the appellant, submits that paper book has been received by her. Accordingly, list this matter for hearing when?
I don't know, my lord, in due course.
In due course.
Obliged.
Supplementary request list. Item 13.
No, this is supplementary. Oh.
Yes. Your Lordship.
Yes.
My lord, I am appearing from Gauhati, my lord.
Yes.
Item number 13, my lord. My lord, today I have some, my lord, some difficulties, my lord. I am taking some more document to prove that, my lord, petitioner before your Lordship was illegally, my lord, without following due process of law was arrested, my lord. So, my lord, I am praying some accommodation, my lord. Matter may come up on, my lord, 10th August, my lord.
No. Supreme Court has said that bail applications have to be disposed of within 2 weeks. We cannot allow. We'll give you till day after tomorrow. If you want to come and appear, you appear. If you don't want, we'll dispose it off.
My lord,
Supreme Court has said 2 weeks. You want to withdraw?
Friday, my lord.
You want to withdraw? File afresh. You do that. We have got to comply with the Supreme Court directions.
My lord, may be taken up on Friday, my lord.
Not Friday, Thursday.
Thursday. Okay, my lord. Done, my lord.
On the prayer of the
Obliged.
Petitioners Council, list the matter on Thursday.
Deeply obliged.
Item 14.
Yes. It's you too.
Item 6.
Item 6 and item 14.
My lord.
Yes.
This is IA application, 148. My grievance is that, let's see, if you take page 29.
Yes.
Page 29 is the index of the caveat application that was on 1st June. Now, this impugn order, we learned, that was filed on 21st May. But they have sufficient time to give us a summons, but it was not done.
Mr. Counsel, this is an appeal filed for the first time. This is the first order of this court issuing notice to you. There is no stay order, there is nothing here. What are you aggrieved with? I don't understand. There's no case. What is that? What is there? Which part of the order hurts your interest? I don't know.
No, when we received that order, we got shocked.
Why?
The old man was shocked.
Why? They can always file an appeal. Whether the appeal will succeed or not, we don't know. We have only issued notice on the appeal. How can you ask for setting aside that order? Supreme Court, when it hears cases, thousands of cases, it issues notice. When there is a case, it issues notice. There is nothing wrong in that. Same thing we are doing. Same thing trial courts are doing. Same thing all the tribunals are doing.
Not even the same breath, I want to request you to kindly recall this ex parte order and then restore the appeal 12 of 2026 and come to the...
What do you mean restore? It is already there. There is nothing to restore. Only notice has been issued. Okay, heard. Right, heard Mr. Learned Counsel for the Joseph Mongsan, Learned Counsel for the applicant. This is in this IA 148. The applicant has put to challenge, the applicant's counsel has submitted that the ex parte order dated 3/6/26 passed in arbitration appeal number 12 of 2026 should be recalled. Next paragraph. The impugned order dated 3/6/2026 passed in arbitration appeal number so is reproduced here in below as follows. It is here page 31. A perusal of the above order clearly shows that the appeal filed by the respondent had been taken up for the first time by this court and notice had been issued to the opposite party. There is nothing that prejudices the applicant herein by the said order. As such, there is no reason to recall the said order dated 3/6/2026. The application is dismissed.
Lordship,
yes.
May I request for the hearing of the WO?
What WO? Hearing of WO? What WO?
No, I'm filing WO in the appeal 12 of 2026.
There's nothing to hear, Mr. Counsel. It's just a question of fact, right? Heard censor. Basically, you just say appeal is allowed. I'll give it now.
Lordship, hearing of the...
Rejected, you go to Supreme Court.
No.
I'm wrong.
Lordship, written...
Mr. Jonathan Lal appears for respondent number 2, in the main appeal.
Lordship, what about this written objections from which I filed?
So, your written objections are considered and rejected. So basically appeal is allowed. The district court
Remand back.
the district court will consider the case on merits.
Yes. Obliged.
Appeal on merits.
Anyone for hearing?
Huh? Who is that?
Anyone for hearing matter?
Oh. I said there is hearing. Oh. Before that, then I'll just say, where is that? Hey, me. I'll just say that in view of the above reasons, the impugned judgment and order dated 8/4/26 passed by the Court of the Additional District Judge Champhai, Mizoram, in arbitration petition number 2 of 2025, being unsustainable, is set aside. The said court shall accordingly consider the application made by the appellant herein under section 34 of the Act on merits. On merit. The appeal is accordingly allowed.
Part 2 hearing, item number 3.
My Lord, the present RFA arises out of impugned judgment and order dated 22nd of August 2025, passed by Senior Civil Judge, Senior Division 2, Aizawl, in civil suit number 37 of 2021. The cause of action in the connected civil suit was the non-compliance of the 2016 agreement jointly executed by the appellant number 1 and 2 and the respondent number 1 and 4 other parties.
You are the plaintiff?
Yes.
Your suit was dismissed?
Not dismissed, my Lord.
Then?
Agreement was...
No. In the district court, what were you?
In the district court upheld the agreement.
But in the district court, were you the plaintiff? Were you the defendant? What were you?
I'm the plaintiff in the district court.
In the plaintiff, you were the district court?
Yes.
So your suit was dismissed?
Not dismissed, my Lord.
Not dismissed? Okay. Not dismissed?
Not dismissed.
Okay. So let us see. What was your suit for?
Suit for there was initially, my Lord, there was an agreement jointly executed by the respondent number 1, number 2, appellant number 1, number 2, respondent number 1, and 4 others who are not joining us today. But the learned civil judge upheld the agreement but refused to enforce it. If my Lord can turn the page 43.
I think it takes some time. My back is hurting me. I think I can't sit. Today I was playing badminton. So in the 4th game, I don't know, I suddenly got this back sprain. So I can't sit for very long. If I sit for very long, it starts paining. So you'll have to excuse me.
Okay, yes, ma'am.
Because they are telling me not to sit for very long.
Yes, my Lord.
We'll do it tomorrow. Let's see. We'll try. Better, okay, next week.
Okay, no.
On the prayer, the parties list the matter in the next week as a fixed item.
4th of August.
4th of August.
On 4th of August.
Oblige, my Lord.
Okay, now then,